Thomas, we're on the record.
Ready. Welcome. We'd like to call the meeting of the Tennessee Real Estate Appraiser Commission for April 2019 to order. I'd like to thank all of you for being here. Thank the commissioners for being here. We've had some experience interviews. Roxana, would you care to go ahead and call the roll, please?
Yes, sir. And notice of this meeting was posted on the board's website on April the 11th. I will start out with, I have two individuals that did let me know they were not coming here. Dr. McCarrum will not be here with us today, and Mark Johnston. I'll start with Randy Thomas.
Present.
Rex Garrison.
Here.
Jim Atwood.
Present.
Jason Bennett.
Here.
Brett Mansfield.
Here.
Michelle Alexander. Here. Thank you. And we also have Rosemary out today, but we have a quorum. Thank you, sir.
All right, very good. We're going to make a motion to adopt the agenda, but before we do, what we're going to do on the adoption of the agenda is adopt the items and the content of the agenda, not necessarily the order. Do I hear a motion?
So moved. Second.
Motion been made and accepted. Motion's been made and seconded to adopt the agenda. Any questions? All those in favor say aye.
Aye.
All those opposed say no. Motion carries. Please review the minutes from the January 14th meeting. If there's any additions or corrections, please speak up. Hearing none, we'll let the minutes go into the, we don't have to vote on those, do we?
We need a motion to
Oh, okay, I'm sorry.
Motion to approve.
Okay.
Second.
Motion's been made and seconded to approve the minutes of January 14th, 2019. All those in favor say aye.
Aye.
Any opposed? All right, motion carries. Go into experience interviews.
Your experience interviews start on page 27 of your iPads. And I can go through. Heidi has done a great job. First of all, I want to thank all the commission members that are doing these interviews before the meeting and in between meetings. It has made an incredible difference, I believe, to our licensees, because if they are done with the exam, then we can go ahead and license them, possibly getting them into the workforce a month or more rapidly. And so on the record, we will read several that have already gone through, as well as the ones today. If it's okay, I'll go through the list. Chairman Thomas?
Sure, please.
One at a time. So for Chairman Randall Thomas, we have one individual, Timothy Jones,
Yes.
and we can vote at the end. Is that okay?
Sure.
For all of them? Okay. Mr. Jim Atwood, on your list, I'll let you, let me go ahead and read your names. You've got Rebecca Andrews, Richard Lyles, Raymond Walker, Bridget Salazar, and Lester Self.
Lester Self is not up for recommendation. He just did the 500-hour interview. The other four, I recommend for approval.
Thank you, and also thank you for helping when candidates want to have those hours reviewed. It's helpful to them, so I appreciate that. Thank you so much. Mr. Brett Mansfield, we have three for you: Anna Jacobs, Andrew German, and Talon Reddy.
Yes to all three.
Thank you. And Ms. Michelle Alexander, we have two: Mr. William Harrison Jr. and Christopher Benton.
Yes to both.
Okay. We will need a motion to accept all of those as they've been voted on.
You've heard the approval of all the candidates. Do I hear a motion to approve education or experience?
So moved.
Motion's been made. Do I hear a second?
Second.
I just have one question before we vote. Wasn't there not a controversy? Tell me about Bridget Salazar. Didn't we?
She was postponed
Oh, okay.
and has subsequently met my requirements.
That's good enough then. Okay, we have a motion and second on the floor to approve the experience interviews. All those in favor say aye.
Aye.
Any opposed? Motion carries. Thank you all for your experience. Now, on the agenda, next on the agenda would be, under normal circumstances, the education report, but we have several people that are here to appear in front of us, and out of respect for their time, where they don't have to sit here and go through the education report with us, I would like to ask that if it's okay with the commission, we go ahead and listen to the special requests that are in front of us. Anybody have any objection to that? Roxana?
Thank you. No, not at all. And
Okay.
if you could both, you could all go back to your iPads. I actually put the appearances on a separate document, so it's not on your main presentation. If you open your appearance, and if it's okay with the commission, we can start in the order that we've saved them.
Sure.
Is that okay?
That'll be fine.
Okay, and I am not 100% certain if everyone was able to come in, so we'll call them, and if
Okay.
they're here, that's fine. If not, you have in front of you on your iPads everything that they know we are presenting.
Okay.
Mr. Glenn McDonald? Okay, so I'll let you proceed with Mr. McDonald. You have his information, and this is an extension request. I believe the first thing you have is the letter.
Mr. McDonald's not here, is that correct?
That is correct.
Okay. Okay, you want to tell us anything about this?
You've got a letter
Right.
from him that is requesting an extension on the information that he's provided to complete, and then he's listing email correspondence and communication where he thinks he was kind of misguided on when he should have applied to take the exam. He basically did not, the board approved him, and from the time an individual is approved to take the exam and to proceed, they have a year's time. So from that moment on, he should have registered to take the exam and passed it. So in his case, I believe his deadline was January. So as of January of 2019, he's gone past the year. The statute, the same piece of the statute that refers to the number of times they may take an exam and continue taking it till they pass, also refers to the section of how long they have to complete it, which is 1 year.
Okay, and you say his time ran out in January 2019, and he passed the test in February 2019? Okay.
So I'll let you read the extension. Like I said, he thinks there was miscommunication with PSI, with board staff. The letter he got when he was approved, and when the board would have approved him, or the commission, should have been clear in several steps that he had a year time.
Okay, no problem.
But in any case, it is at your discretion, which is why you have it.
We do have the authority to extend.
You do have the authority to extend the year's time, since he's already passed the exam.
Sure.
He was a month past.
Okay, I'll open the floor for discussion on this one, if anybody wants to discuss it.
I make a motion, we extend. Do we have to have a date?
He's already passed the
He's already
exam,
passed, yeah.
so if you extended it, then he would be able, I think otherwise he meets everything else, Heidi? So far. So once we get everything else, we'll
Make the motion that we extend.
All right, motion's been made to extend. Do I hear a second?
Second.
Motion been made and seconded to extend Mr. McDonald's criteria. Any discussion? Hearing none. All those in favor to extend, say aye.
Aye.
Any opposed? Motion carries. Thank you, Mr. McDonald.
Thank you. Our next applicant, and I will try not to truly hurt the last name, Chris Jakubaskas. Did I come on up, Chris? I apologize. Roxana.
Chris Jakubaskas.
Nice to
Pleasure.
meet you. Go ahead and sign in.
You got it.
You'll need this to be read to answer their questions. I appreciate it.
Welcome, Chris.
Morning, gentlemen. Thank you for having me. And ladies, excuse I'm here this morning to appeal to the board. I know Miss Heidi's helped me out thoroughly with this. Unfortunate events, I've taken the test and exhausted my number of attempts at 4. My wife and I recently had our first child, and that has proven to be a little bit more taxing than I previously thought. I'm here to appeal for the board to allow me one final attempt to pass the exam, which is probably all I'll need this time since she's almost a year old and she's pretty self-sufficient now with mama. So I can devote a lot more time than I think I did the previous 4 times and looking to pass it and get certified and move on with the process.
Artie? Open up discussion from the commission.
I've got something. So I interviewed Chris, and speaking with him and reviewing his work, he's well versed in the appraisal practices and procedures. He's very knowledgeable. His reports were very good, and so I think an extension would be more than fair in his case.
Was that a motion?
Yes, I make a motion. What's the time frame? Do we?
Roxanna, what's a normal time frame?
You can add an extra year, you can take the exam once, that would be at your discretion.
Chris, when do you plan on taking it?
As soon as I can. As soon as I can. I've been studying ever since the last test, so I'm ready to rock and roll.
If you want to say a year or 6 months, or
Okay, with a year, can you fit
That's
that in?
fine. Yeah,
Okay.
it will not be that far.
Yeah, I'll make
I have
a
to
motion.
renew my trainee license in June, so it will definitely be before June.
okay, all right.
I'll make a motion that we extend his opportunity to retake the test for another year.
All right, motion been made. Do I hear a second?
Second.
Motion been made and second to extend Chris's time to 1 year. Any discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? All right, Chris, you got a year.
Thank you very much. I
Thank you,
appreciate your
sir.
time.
Appreciate you.
Thank you very much. I appreciate it.
Take care. Thank you. Next on your iPads, you have Mr. Batson. Danny? For any questions they asked.
All right.
Not had a chance to review the applications again. These were not emailed to you. You've got them on your iPad. The presentation for Mr. Batson starts on page 23. He has not officially applied with the board yet for his license. He is wanting the board to take consideration of asking him questions since he's looking at the information. This would be a felony applicant. So if you have questions, we've never addressed the Fresh Start Act. But if you denied a felony applicant, Anna can answer some questions, and you'd have to go by certain steps. But for now, take a minute to look at everything and ask him questions, and we can go from there.
All right, welcome, Danny. Appreciate you coming in front of us.
Thank you.
You're a Navy veteran?
Yes, sir.
All righty. I'll open the floor for discussion from the commission. Do you want to make an opening statement?
I do, yes, sir.
Yeah, let's do
That's
that.
I just want to write out some stuff, and I want to thank you guys for allowing me, and thank you all for allowing me to present my case today. I'm here requesting an opportunity to get my appraiser license reinstated. I've hit a rough spot in my life, and now trying to rebuild. I went through a nasty divorce and have lost everything in the process. This is the first step to getting my life back on track. I was advised by my attorney to take a plea deal on my case to avoid further litigation and fees. I have been certified residential appraisal for 14 years. Prior to all this, my situation with the divorce, I've completed over 3,500 appraisals throughout my career. I've never been in trouble with the law in the past. I'm a native Tennessean. I'm a graduate of MTSU with honors, as well as being a U.S. Navy veteran. None of these charges were due to my work product as an appraiser. I was a real estate broker as well for 14 years, as well as an auctioneer. I've kept my standing well maintained in my appraiser career. Some of my peers are here today to give a character witness of me as a person as well as my work product. Please allow me to reinstate my appraiser license so that I can rebuild my life and take care of my daughters. Thank you for your consideration.
Ready. Thank you. Questions from the commission?
Roxanne, you said something about a fresh start. What exactly is that?
So last year, the Fresh Start Act went into effect July 1st, 2018. And so if a regulatory board or an occupational licensing board makes a decision by an applicant either to apply or to license based on a past criminal conviction, then the Fresh Start Act is supposed to be taken into effect. So the Fresh Start Act we would have to, if you were to deny a licensee, it gives them a certain avenue if we were to deny the license based on an appeal right, but it also gives the commission the discretion to deny a license if it is determined that their criminal conviction is directly related to the profession. Certain convictions are there is a rebuttable presumption that they directly apply to the profession, such as Class A, B, or C felonies, which is what we have before us today. Prior to the Fresh Start Act, certain commissions and boards had blanket rules that would deny applicants licensure without any consideration for past criminal convictions. Our rules have a provision that says applicants that have been convicted of or pled guilty to a felony in the past 5 years immediately preceding the date of application shall be denied a license, or are not eligible for registration, license, or certification. So in these instances, what would happen is we would bring an individual that falls into the categories before the commission for you to make a determination whether or not you would like to license the individual. If you choose to license the individual, that is fine. That is certainly within your authority. But if you do not choose to license the individual, there are certain steps that we would have to go through on the record to make that justification. Have any additional questions?
I didn't get the 5-year deal.
So based on the appraisers rules, so 1255 hold on one second, 0109 1B1, it states that if an applicant has been convicted of a felony in a domestic or foreign court during 5-year period immediately preceding the date of application for licensing or certification. So he's been convicted, the indictment date on these were in 2016. So applies to individuals that are reinstating their license as well. So our rules say that you're not eligible for you shall not be eligible, but the Fresh Start Act was passed, so we have to take that into consideration. Normally it would be a blanket denial, but now we have to bring it before.
So we can, based upon that new law or rule, override the 5-year deal?
Yes.
Okay.
Am I correct in saying this is a Class C felony?
That's correct. There are 3 different Class C felonies.
Where is that listed?
It's on your iPads. If you will look,
Page 32 on your iPad.
yes. It's in the box. C is circled and
You said you were an appraiser for 14 years.
That's correct.
You ever had any discipline before that?
I have not, no, sir.
Did your license, did it expire? How did that?
It expired.
Okay. What's the process of reinstatement? I mean, do you education or is it?
Education and exam. Full application.
Yes, to take the exam again?
Gauntlet of the education requirements.
Correct. It's a lot, which is the reason he wanted to appear before the commission before he embarked on that.
Say full, I'm sorry, was it a residential license?
Certified residential, yes, ma'am.
About the experience, since he's have to work under a supervisor. Okay.
I think it's the education and the exam. I think the last one that we had reapply was 2015, I want to say, which is what started us to look at how involved this would be.
Mr. Chairman, I am familiar with Mr. Batson in some of this, so I think I should recuse myself from this vote.
Okay. That leave us enough to vote?
Bring one of my character witnesses up.
Hang on just a second. Does that leave us enough to vote?
Yes, you just need 5.
Okay.
For quorum, so that leaves us enough. And it's at the discretion of the commission if you want to discuss further, have any character witnesses. We're just going to definitely mark that Mr. Atwood won't be voting, but it still leaves you quorum.
There's a pleasure of the commission need to hear the character references, witnesses. We'll make you all better, or? Okay. All right, yeah, bring your witnesses if you don't mind.
Hey, Representative Bill Beck.
Hi, my name's Bill Beck. Oh, you mean sign in?
Yes, thank you, sir. I appreciate you being here. Thank you.
And I appreciate each and every one of you's service on this board. I'm a not retired, but I retired my appraiser's license. Still have a real estate license, and I'm a practicing attorney. Mr. Batson came to work as my apprentice attorney in 2002. He worked for me approximately 2 years before, like any young man, he decided to strike out on his own and start his own company and got his full appraiser's license. Mr. Batson is a man who is honest, the highest integrity. He was a hard-working, loves appraisals. He came to me. He had been working as an apprentice appraiser with a different firm, but he was more interested in how to generate reports of the highest quality, and we worked with him on that. He's a fast learner. Matter of fact, while he was in my employ, he bought his first house. I was in a position to loan him the money for his down payment. He repaid me with promptly as he worked and made the funds. Just a remarkable young man, and I believe that if you can find it within your jurisdiction, which I think you can, that he is worthy of us helping him, giving him a hand up. I myself am willing to work with him to help him with his future goals and his future efforts going forward. He's just, I just can't say enough good things about Mr. Batson. He really is a good man, and he really could use our hand up. And I appreciate your consideration. I appreciate your time, and I appreciate you letting me testify this morning.
What else?
I do. It's Don Burnell.
I'm Burnell, an appraiser in Nashville here, and Danny, I work with him. He came to us about 18, 19 years ago, and he started out that way with us. That's where he began. We and worked with him for a few years, and then he decided to go out, went to somebody else, either just trying to get ahead faster. We had other appraisers he was competing with, so he kind of went out a little further. He said, look, I can go to the Becks over here and get a little bit better start faster, but enjoyed every minute. And since he left, he's called me. We communicate all the time. He is just a great person and has worked hard at the profession, and I totally recommend.
Now, look me in the eye.
Yes.
Do you trust him?
Yes, I do.
That's all I want to know.
Yes, sir.
Other questions?
The Fresh Start program specifically states as long as the charge is not associated with the profession, correct?
So when you make a determination whether to deny an applicant or you're looking at a conviction, you have to make the argument that it directly relates to the profession.
So, you correct me if I'm wrong, the charge is assault?
That's correct, yes, sir.
All this was involved with a divorce, am I correct? Okay, okay. Anybody else have any questions for him? I'll entertain a motion from the floor. All right, Roxanne, I'm going to need some help from you. What we're going to need to do is discuss it. We're not allowed to discuss it by ourselves.
Correct. This is the time and place for you to discuss it, read over it, ask.
Mr. Batson, it states on here that you entered into this agreement, I guess, in 2017. Does that look correct? And you've been on probation since then?
Yes, sir.
Have you had any issues whatsoever or violated any terms of your probation at all?
I did. It was in regards to the divorce. It was swapping out the kids is what it was over with, and so that was where I violated.
Elaborate on that at all? You had contact? Is that okay? When was that?
2017.
What I'd like to hear, define contact.
I passed her on interstate.
Oh, okay. I mean, we're not talking about physical contact.
No.
Okay, okay.
Is this still in effect that you have to get approval to go to Williamson County?
That's correct.
And that's for the duration
Yeah.
of your probation?
Yeah.
In your violation, did you end up having to do any additional time?
I did.
Okay. How much additional time for your violation, did you have to spend in?
4 months.
Roxana, so the Fresh Start Act applies if we deny him.
That is correct.
Then he has additional process to go through.
Anna would read 6 questions, and she'll correct me if I'm wrong, and you'll have to answer as they pertain to the industry. Don't, then that would not apply.
Okay, so if we do deny, she reads the 6 questions. If he qualifies for those 6 questions, if they're yes or no, is it a yes or no?
So it's there are certain factors that you have to look at, and I can just read them to you since everyone's not as familiar. It's not necessarily a yes or no. These factors are designed for everyone to have a conversation about the specific criminal conviction and its relationship to the industry. So you would want to consider the first one is the nature and seriousness of the crime for which the individual was convicted, length of time since the commission of the crime, the relationship between the nature of the crime and the purposes for regulating the profession, the relationship between the crime and the ability, capacity, and fitness required to perform the duties and discharge the responsibilities of the profession, any evidence of rehabilitation or treatment undertaken by the individual that might mitigate against the relationship of the crime to the profession, and any applicable federal laws regarding an individual's participation in the profession. Those are the different factors to consider whether to deny an applicant for a license, certificate of registration, or whether to renew a license, certificate, or registration on the basis of a criminal conviction that a licensing authority must consider.
Batson, did you complete any required treatment?
I did everything that they've asked me to do.
Okay.
Yep.
Mr. Batson, are you based out of Nashville? I mean, is that, so Williamson County is part of the metro area, so you would be prohibited from working in,
The restriction
it's
is
only for the period.
if it's related to work, I can go in there. I just have to let them know.
In your previous life as an appraiser, you went into Williamson County?
All the time. I lived in Williams County.
Oh, okay. You lost me. You live in Williamson County, but you have to report
No, at the time.
Oh, at the time you lived, okay,
Yeah,
okay.
Prior to my divorce.
Okay,
I moved out there for my kids.
okay. How many children you got?
I got two.
All right.
First, I think, the fact that you're a veteran, Navy veteran, so I want to thank you for your service. From my perspective, it's a serious, obviously, allegation, but I feel like, based on the information that we've been provided, that you've served your time and paid your dues, and hopefully your entire life won't be, won't be dictated by this single incident. So the fact that you have to go through the education requirements again and take the state exam, I would make the motion that you are allowed that opportunity.
Motion's been made to approve the opportunity to reinstate his license. Do I hear a second?
Second.
Thank you. Motion's been made and second that Mr. Batson have the opportunity to reinstate his license. Any further discussion from the commission?
Hey, I may do a roll call,
No problem.
since we're down.
Hang on,
to-
we're still in discussion.
Oh, yeah. I apologize.
Anybody have any discussion? All right, Roxanne, take a roll call.
I got it. Last sheet. All right, I just didn't want to mark them wrong. So the vote is a motion to allow Mr. Batson to reinstate his license. Mr. Randall Thomas?
Yes.
Mr. Rex Garrison?
Yes.
Mr. Jim Atwood is abstaining. Mr. Jason Bennett?
No.
Mr. Brett Mansfield? Yes. And Ms. Michelle Alexander?
No.
Out of 5 that make up the quorum, we have 2 noes, so the yeses win, and he's approved the process to reinstate his license.
Thank you.
Batson, we wish you the best of luck.
Thank you so much.
Thank you.
Thanks.
All right, Roxanne, you're up again.
Thank you. Give me a minute to move my forms. Next, you have on your iPads Mr. Albert, I believe it's Fajit. Fate. I knew it was simpler than what I was saying. That's okay.
Correctly,
That's correct.
ever.
Go ahead and sign in if you could. A minute, and we can get to his application. You've got on your iPad, starting on page 35, a letter from Mr. Fate. Thank you for coming here in person. I think it's helpful if you're able to answer the questions. This is discipline of consideration, and it is in the industry, so I want to make sure to give the commission time to review what the ask any questions. So we don't currently have an application on file for him, but he can answer hopefully any questions that you have, and we can go from there. Way too much.
All right, you've all had a chance to look at this, at least it's in some part. I'm going to call you Albert, is that okay?
Yes, sir.
Would you care to make an opening statement?
Well, I appreciate the opportunity to be here. Thank you, ladies and gentlemen. And would like nothing more than the enter appraising, a line of work that I thoroughly enjoyed. I feel that I was unjustly treated in Colorado, in the state of Colorado, and did not have the financial resources to fight for myself as far as I would have been able to take it.
Mr. Chairman, I'd like to make one clarification. The Fresh Start Act does not apply to this individual because the Fresh Start Act is based on past criminal convictions, and this is an administrative conviction by a regulatory board.
I did not know that, but the reason I'm here today is before I begin the process of reapplying, redoing the education, both of things I'm more than happy to do, as I have been out of the industry since 2007. I just wanted to make sure that you, ladies and gentlemen, would allow me to become a licensed appraiser. At the time that the complaint was filed against me in the state of Colorado, I had actually been approved to become a certified residential appraiser in the state. The two things happened within about 3 weeks of each other. So,
What did you do from 2007 till today?
I have worked in a variety of jobs. Worked in the golf business, the golf industry.
Questions from the commission?
Our attorney, do we have in our possession the legal documents from Colorado describing this situation?
So on your iPads, on page 36, you have the stipulation and final agency order, Colorado.
Reading it, does it specify the details? Am I missing something?
Easiest way to do it. Mr. Albert, tell us what happened.
Paragraph 4.
Just tell us what happened in your words.
Well, I went through the licensee trainee process. As soon as I got my appraisal license, I struck out to expand my business. I undercut a long-standing appraiser in Colorado's fees and took a lot of his work. He subsequently filed a complaint against me with the state. At the time, a woman appointed director, Sarah Toll. She was appointed to the head of the commission with a goal to find and convict appraisers as they felt the foreclosure rate in Colorado was a problem. I will say that unbeknownst to me, a lender I was doing work for was doing illegal acts. I had no knowledge of what they were doing as far as their loan processes and applications, and I stand, as I did then today, I stood by my appraisal work, the integrity of my work, and felt that, I was kind of caught up in a rush to judgment to quote-unquote clean things up. The director of that board, after went through my process, she was censured. She was then fired. She has since then been sued and since then been disbarred as an attorney.
Elaborate a little bit specifically on what the issues they had with your reports were?
The appraiser in question that filed the complaint, he had a long-standing working relationship with several of the banks in Pueblo, Colorado, Canyon City, Colorado, and I believe that he got his hands on something along the lines of over 80 reports that I completed. Was able to sit down and go through them to look for errors that ran from anything from grammar and spelling errors to common errors in my reports. So when the complaint against me was basically levied, they claimed gross misnegligence and totaled up the errors in my reports, some of them ranging from discrepancies in lot size, square footage, discrepancies in measuring a house, as little as a couple square feet. And when some of the loans that were made against those properties went into foreclosure, then the value of my appraisals were brought in discrepancy based on some of the foreclosure resales and rates. I fought the complaint until I ran out of money. And at the point then when I ran out of money, I'm married, still married. I had 2 small children. I had no choice but to sign the agreement that was brought, that they brought forth to put it into it. As my attorney quoted me, a minimum of $125,000 to take it to the state Supreme Court to fight the state itself. And so I really had no choice but to sign it because nothing else I could do.
Reached out to any appraisers in the Cookeville area about potential sponsorship?
Yes.
Okay.
Actually, the gentleman who trained me in Colorado is an appraiser here in the state, and said he would be more than happy to take me back on, as he knows the work that I do and did out there. But I did not want to embark on that process to complete it all, to then have the answer be based on what you previously happened and done. The answer is no then. So I think you guys can appreciate it.
Sure. Everything that I see here says, it appears to me that if he's going to reapply in Colorado, did you try to reapply in Colorado?
No.
Okay. So, am I reading that wrong? Because everything, it looks like it says these are subsequent if he's going to reapply in Colorado. Is that applicable to Tennessee also?
Well, in our rules and statutes, since he has been disciplined prior by another regulatory board, you're allowed to deny their licensure based on a revocation, suspension, or other disciplinary actions. And so he voluntarily surrendered his license, which is in this order the same as revocation. So that is why we brought it before you. So based on his past discipline, that can impact whether you would like to license him here.
And just for clarification, the sponsor that you're referring to, is he in the Cookeville area?
Yes.
Okay.
Yeah. He's a certified residential appraiser, long time good standing.
In your letter to us, you used the word fraudulent, but I didn't hear any fraudulent behavior in your description. Is that an incorrect word?
I'm sorry, I don't have...
Were you accused of fraud
No. No, sir.
and found guilty of fraud of any kind?
No, sir.
So the word in your letter probably should have been used. You should have used another word. I'm in paragraph 2.
Yes, I see what you're saying. Yeah, I guess I should have used a different word. No, I was never accused of fraud. I was never convicted. I never admitted any wrongdoing to the board. I guess that I was accused of doing improper work.
Prior to this particular situation, had you had a complaint filed against you? This was your first
Yes.
complaint,
Yes, first and only.
but it involved multiple properties.
That is correct,
Up to 80
yes.
properties.
Well, I believe the number of properties listed in the complaint, I don't remember how many were listed in there, but he was able to sit down and go through over 80 reports looking for anything that he could find to make complaints on, and then kind of make a larger, more impactful complaint to the state. And also, when the state investigator went to review these reports and appraisals, they did it in his office, using his helpers to review my own reports.
So the total monetary penalty was $46,000.
It was cut down from that to 10.
So I don't see the correlation. That's a heavy penalty between
It
there
is.
and the common errors that you're referencing.
The total number of errors, they ranged everything from that they used to levy the fine and make the complaint was everything from spelling errors on up to said I had doors swinging the wrong way on my sketch. There were none of the complaints they brought alleged that I made up comps or said buildings that weren't there, added square footage, erroneously inflated value.
There's specific use map violations that were enumerated.
Not to my knowledge, no.
Identified. Door swinging the wrong way on the sketch is not a use map violation that I know of.
Correct.
And spelling errors are not. Now, a series of errors that in and of themselves are minor, but in the aggregate would lead to misleading or assignment result. That would be a use map violation.
It never, the complaint never got to that point, as I was unable to take it to that point monetarily. I was never able to take it and fight it and make the state present their case in court.
Have any other documentation outlining the results of their findings that maybe we're not privy to? We don't.
I
have
do
any?
not, no. All I have is the final resolution that I provided to you.
So the final order before you is an agreed order, meaning that the applicant settled this case prior to it going before an administrative hearing. So he neither, in agreeing to voluntarily surrender his license, neither admitted nor denied any of the actions that were alleged by the courts. So it did not go to a hearing, but complaints were filed, and he voluntarily surrendered license permanently, and that is equivalent to revocation of licensure in Colorado.
Any discussion of possible criminal charges had this progressed?
No.
Volunteering to withdraw his license, there was no consent order. It was a voluntary agreement.
So the order that you have before you is, so if you
So
look,
vague to me. I don't see what I'm looking for.
it is vague in the fact that we don't have the alleged facts that were before us. We just have the specific properties that were in question, which is outlined in paragraph 4. And then in paragraph 6, we have all of the respondent and board's agreed terms with the fine and staying the procedures in the surrender / revocation.
Robert, how long you had your license before 2007?
I was given my license in 2004 as a licensee, and of course worked on the requirements before that.
So,
2004 to 2007 when I entered into the agreement.
and you have, am I correct to say you have not applied to the state of Tennessee yet?
No, sir.
Okay, so you'd have to just start from ground zero again?
Yes.
Okay.
And I understand that. That's not
Sure.
a problem.
Sure.
And as I said, I was under the impression, and she says that's not the case, I was under the impression that under the Fresh Start Act, I could then make this attempt to apply, which is the reason I'm doing it.
Sure, we appreciate it.
But I certainly didn't want to go through the process if the answer was going to be a no.
Right.
Spend the time and the money, of course.
All right. Any further questions for the gentleman?
So the supervisor that you had in Colorado when you got your license is the same supervisor that you would have in Tennessee?
Yes.
Did I understand that
Yes, ma'am.
correctly?
That is correct.
Not your supervisor who turned you in to begin with, it was another appraiser.
Oh, it was another rival appraiser,
All right,
yes.
thank you.
Any further discussion? Anyone wish to make a motion?
Yeah, I'll make one. I would like to make the motion that we accept Mr. Albert's request to be reinstated as an appraiser or whatever I'm supposed to say.
Okay.
That we accept him. I think, looking at him, I think we have a man that wants to do it right.
Motion's been made to assist Mr. Albert to reinstate his license. Do I hear a second?
Second.
Motion been made and second. Any further discussion at this point?
Will this come up, will this particular topic come up when he comes before the state for his license? Will this be a part of his record that is considered?
It will be, and at that time, we'll probably have a copy of the letter we'll send him saying that the commission did approve him at that time with what they looked at. The only reason I can see there being a change is if anything, as we get to the end, comes up that we find or he turns in that's different, then you would need to review the discipline again, but otherwise you wouldn't be reviewing the discipline. You'd be interviewing him just like you would anyone else.
The interviewer know?
Not
that
necessarily,
this
not if
took
it's
place?
not if it's been resolved.
Okay.
The interview would be about his work at that time, I believe.
Get to see the experience and look
You'd
through
get to
that.
see the experience, his exams, we'd like him just like we would anyone else, which was his concern for it being reviewed now. The only thing that I can think of that would change is if we found other information that you have not heard today. But if not,
Artie, any further discussion? Motion been made and seconded to extend, do we have a period, no, he just has to start over, I guess, there is no period of time. Okay, to allow Albert to continue, all those, you want to take a verbal vote?
yeah, let's go ahead since we
Okay.
did last time, just to be sure. Mr. Randall Thomas?
Yes.
Mr. Rex Garrison?
Yes.
Mr. Jim Atwood?
Yes.
Mr. Jason Bennett?
Yes.
Mr. Brett Mansfield?
No.
Ms. Michelle Alexander?
Yes.
We have 4 yeses and 1 no, so he would be, based on the discipline that's been presented, he would be approved to continue on the application process.
All right, thank you, Albert.
Great, thank you, ladies and gentlemen, for your time. Thank you.
Ernie?
Thank you. On your appearing before the board, I think we have our final individual, Mr. Matthew Edmondson. Okay, and Mr. Edmondson is not appearing before you. You have his documents starting on your iPads with page 43. He is applying for a license via reciprocity. It's a certified general license. The first document is an email that he has provided. Basically, his application was denied in January of 2019 by the office, and that would be applications that Anna and myself look at that have discipline that concerns us, and it's based on revocation in 2 other states. So we'll let you look at his documentation.
He has applied at this time for Tennessee.
He has, and
Okay.
based on our process, we have denied him because of the discipline in the industry. However, since then, he's changed. He has gotten accepted in 2 other states, which at the time we denied him, he had not been. So you'd be looking at the full package, including a new license that he has in Mississippi and Louisiana, which he did not at that time. So we'll let you review it all, and the commission has the discretion when they receive that information, obviously, to come before you and say, no, here's what you're missing, or here's what is. And that is drilling going on. We apologize. It took several brains to figure out what it is. We've got construction all over the building, so I guess as it's moving down, it's going to impact our meetings.
He's turned in everything that he needs to. He just needs our either acceptance or denial.
Correct, based
Okay.
on the discipline. And so the letter that you see on page, what is this on your iPads? Page 46 is our letter he's received. And then his history from 2018 is there. He does have a letter of good standing from a state. And like I said, he's been accepted and licensed since then in 2 states. So you have everything before you. I regret that he's not here to answer questions. So if you have questions and he can't answer them, there's nothing we can do. We would be forced to delay it until he can come in person. The cases go back to 2014, way on page 60. You'll see the House Representative's letter from his state. All those are about the discipline in his state.
Which one is his state, Arkansas? Yes. He has discipline in his state, but he still has license in his own state.
In Louisiana are his 2 new licenses.
He doesn't have a license.
But he has
Current
discipline.
letter of good standing from his state.
He has discipline in his state, Arkansas, but he has a letter of good standing from his state.
Afterwards.
Afterwards.
The case is from 2014, I believe.
Is Mississippi his temporary license?
His letter of good standing in Arkansas is current, as of today, is current.
It's from November 13th of 2018. It's after the fact, yes. Yes. Like it's for 6 months.
All right. We'll open the floor for discussion on Matthew Edmondson's discipline consideration. Any discussion? How long, if I get in trouble in Tennessee, which is just a matter of time, how long is it before I can get a letter of good standing with you?
As soon as you comply with everything that you're required to comply with.
Yes. So there is a time limit in our rules for criminal convictions, but not for discipline from another licensing authority. So if you look at the letter, we based the prior decision off of Rule 1255-01-.09 2D1. The provisions are provided for you there in the letter.
Just out of geographic proximity, Michelle, do you know him?
No.
Just figured coming from Arkansas, Mississippi, he might be in the Memphis area.
I do not know him. Am somewhat familiar with this complaint, having heard about it.
Yeah. Okay. Any recommendations or discussions?
He's been denied in 2 other states then, far as
Approved, right? He was approved.
Approved.
he's been approved.
Since then. After our letter, his Louisiana's approval was sometime in January, and I don't think I see an expiration. Provided us this record. The card that he provided for Mississippi, which is on page 51, says temporary license privileges for 6 months. So both of those are since our letter went out. But you all have not had a chance to see the complaints in the entirety of the case.
Did he tell you he's going to be here?
To be very honest with you, I don't recall
Okay.
if he was or not, so I would be wrong to say either way.
Okay.
I know we communicated, I know that I mentioned that, but he's not in Tennessee right now, so I knew it was going to be. We were going to offer the availability of a conference call-in line and just didn't get a chance to communicate.
And if you were interested, the specific facts for this, I know we were looking at that for the previous applicant. Again, on page 61.
61?
Yes. And the findings of fact and conclusions of law begin on 65. There are several emails in between.
There are 3 respondents, but we're only looking at one.
Yes, it's the only one that is applied here.
It is the Eric Edmondson, is that the right? Okay.
Matthew
Matthew
yes,
Edmondson.
Matthew
Oh,
Edmondson.
Matthew.
His name is Eric.
Matthew Edmondson, okay.
Discussion?
He's also, it looks like, a member of the Appraisal Institute. There's a
Pleasure of the commission. You recommend, Roxanne, if we're at a stalemate?
We sent out the letter evaluating everything to the best that we could between Ann and I, so this would be at the discretion of.
All right, ladies and gentlemen, let's go.
I'll make a motion, we decline the request.
Second.
Motion's been made and second to decline the request. Any further discussion? Hearing none, all those in favor of declining the request say aye.
Aye.
Any opposed? Is it remotely possible to get some more information on this? I just feel like we got kind of dumped in the middle of this one, and there's a lot that I'd like to know that I don't know.
Such as what type of information?
Well, just, I mean, the whole thing is, we're looking at one person here, and it's like 17 different pages. I would have almost, just if we can just have some time to take the time to look at it, but of course, we've already voted now, there's no problem. I understand that, but in a situation like this, I'd like to have some time maybe to look at what I'm looking at.
Now, if you prefer, we can go back to it.
No, we've already voted. That's no.
Okay.
We voted. That's good enough.
Do you mean send them to you in advance?
Well, that probably, I don't know that that's.
And there's, and
Yeah,
it's not to
I
say
can
we
see where that
can't.
might be a problem, too,
There's just
yeah.
a lot of information
Right.
on these if we're talking about disciplining your industry
Right.
or felony.
Right.
So, we could, if you would like to send it in advance, redact all of personal information if there's a concern there, and have it sent to you that way.
That'd be fine.
And then when it comes meeting time, the personal information, we can have it appear again. So if you have a conflict, then after knowing the person, you can recuse yourself.
Is it far as the confidential nature of the information that is being sent?
It's like, well, as we've said, there's a lot of personal information here, but this isn't, we can certainly send it beforehand. It's been done elsewhere, and on other boards and commissions. I just do not know if it's been done on board or this board or commission prior to. So if I would just say, as you get the other information, just when you receive that in your email, make sure that you don't discuss it with anyone or disseminate it otherwise.
Once it goes through this meeting, it becomes public, doesn't it?
Well, yes, it does. You're correct. It becomes public information there. We just redact, as you saw before, we redacted the identifying information, so it can be sent to you beforehand, if that is the commission's preference.
All right, thank you very much. Go ahead, Jim.
Just a point of or question of clarification. Yes, there were some things presented to us today that were very personal, and we're on live. And so, as a board, how much discretion in that personal information are we supposed to be a part of, knowing that we're live? I mean, I didn't feel comfortable enumerating the charges certain people might have had that came before us today, but I had questions on those things. So how far should I go with that?
You are allowed to ask questions, any questions that you believe will help you make your determination. So the fact that an individual has a particular criminal conviction, that information is not sealed. So because we have it, it's a matter of public record. Another individual could request it from us. It's just certain times you don't want to go into different questioning where you are not focusing on what it has to do with the profession. So ultimately, you're making a decision whether or not the individual has the ability to be an effective real estate appraiser. So if you want to know the details of what happened, because you believe that those details may directly relate to the industry, you are allowed to ask those questions. I would encourage the commission not to go into too many personal details, as that necessarily is not relevant to the issue. So anything that you believe is relevant, you can ask. That's the point of an individual coming here, and for you guys to have the opportunity to get to know and understand it more. So I would just, any information that's on the iPad, that's public information. Nothing, we are not going to provide anything to you that has been sealed, because we don't have that, or anything that has been expunged, because that would not come before you. So anything that is presented before you that is absolutely
I'm going to try to ask this as general as I know how to do it,
Okay.
and you still understand what I'm asking. If an individual is guilty of some type of felony activity, whatever it may be, that And then we're going to, if approved, to reinstate license, we're going to send them into the homes of private citizens of our state.
Correct.
We need to know whether the activity is going to continue, and are we protecting the safety? I mean, we can't do, we don't know how a person's going to act in the future, but we need to have some degree of confidence they're not going to do that.
Right.
Because when we send them on a residential appraisal, they're going into homes with children and people, and that's important to us. So we have the right to ask questions to feel comfortable that we're not sending somebody out that's going to harm our citizens.
Absolutely, you have that right. And as we said before, certain felony convictions, such as ones that may be Class A, B, or C felonies, those are the more severe. Those, according to the Fresh Start Act, have a rebuttable presumption as to applying to your profession. So if you see that happen in the future, just think of that. As you said, we want to make sure that, because especially, you said, individuals are going into anyone's homes, maybe in individuals' cars, or those different kinds of things, you can ask any question that you believe will help you make a determination one way or another, because ultimately our job is to protect the consumers. That's what we're doing here, consumer protection. So if there's a felony that comes before you, it's usually a very serious allegation. Take all of that into consideration. Ask any questions that you feel comfortable with. If we're going down a line that maybe we don't need to, I will certainly be here to help guide you through that.
Okay, this concludes the personal appearances and special requests.
Yes, sir.
All right, let's take a 10-minute break. Get back here in 10 minutes.
All set.
Call the meeting back to order. Education report. Dr. McCarron is not here. Are you going to do it, Roxanna?
I'll be happy to. Your education report is on your previous presentation, the one that is not your appearing before the board, and it is on page 27. I believe he's gone through everything that we had, and you'll see before you. This was also emailed to you, so he's approved all those courses, and we would need a motion.
Okay, page 28.
I apologize. Yes, page 28.
Move to accept.
Second.
All right, we've had a motion and a second to approve the Education Committee report. Any further discussion? All those in favor say aye.
Aye.
Any opposed, say no. Motion carries. Next item, is that legal?
Yes, sir. We will
Okay.
turn it over to Anna and Denard.
All right, now, and we're going to turn it over to Anna and Denard, but before we do, there's a few things I want to do, if you don't mind. Since you sent this to us, and having done my homework like I'm supposed to, am I correct to say that number 4, number 5, okay, number 3, 4, 5, and 6 are the same individual, the same company, considering that's the same expiration date and the same penalty? Okay?
Yes.
Okay, Commissioners, 3, 4, 5, and 6, if it doesn't offend you, I'd like to vote on those all at once, just to get those out of the way, because it's all the same thing, and it's going to be exactly the same vote, I would anticipate. So you can read those numbers, if you'd like, into the record.
For the record, number 3 is 2018-07-4401. Number 4 is 2018-08-03.
Okay, stop. I'm wrong. It's 4, 5, 6, and 7, not 3. I'm wrong.
It's 4 through
Okay.
7.
I'm sorry. Take 2. Okay, we'll edit that part out. So number 4, 2018-080351. Number 5 is 2018-088271. Number 6 is 2019-004991. And number 7 is 2018.
No.
You said 4, 5, 6?
Yeah.
That's it?
Yeah,
Okay,
that's it.
all right, so scratch that. So number 3, 4, 4, 5, and 6. Okay, now we're on the same page. All right.
7 is the same one.
7 is
7's the
part
same
of
one.
it. Yep,
There's 4 of
yep,
them.
yep.
I think that's a different,
We took
7's
2.
different.
Yeah, you're going to need to look at your iPads, not your paper, because we took 2 cases out from what I had
Oh,
emailed
okay,
you.
okay, I'm sorry.
Yes.
What
So
page we want on the iPad?
on your iPads, your legal report starts on page 29 through page 49.
Okay.
Yeah.
So you took 2 out.
Three, 4, 5, and 6.
Yeah, so we do need 3, okay,
5 and 6.
okay. Take 3.
Okay, take 3. Testing. Okay. So just read number. Okay, number 3, 2018-074401.
Okay. So we're going to vote on those 3, 4, 5, and 6 together. 3, 4, 5, and 6 on the iPad, not your paper.
3 is different.
It has a different
I think it's a different.
recommendation.
Yeah, it's got a different recommendation. I think it's a different company. 4, 5, and 6 are the same. 3 is separate.
Licensing
Everything
history.
started, it's exactly the same, but you say 3 has a different
All the
recommendation?
do all AMC licenses have they don't have all the same date?
No,
Just initial, like when you initially registered, there should be a whole bunch that have the.
right. No, their dates vary.
Okay, go ahead, I'm sorry.
Okay, just for the record, 3, 4, 5, and 6 are all the same company. They do have a different recommendation because number 3, they did the respondent did end up paying some part of the money. Like all 4 of these are for failure to pay.
Right.
And then the company itself, I mean, I guess we're just going to get into it if that's okay with you.
Sure, go ahead.
Okay, so this is all the same AMC. They are in financial difficulties. They have not paid anyone. We've got these 4 outstanding complaints, and one of the complaints they did make a partial payment. So it did have a slightly different recommendation, but everything else, it's the same company.
If you have any additional complaints from this company ongoing,
We'll look that up, but I think we might have some more in the pipeline.
This is the one where it said they thought in April of 2019, they had not yet filed bankruptcy.
Right.
Are they still in business?
As far as before we presented the report, they were still, I think, working, but they have not paid anyone, and they have not filed for bankruptcy yet.
Are they still working, what your definition there, in Tennessee?
It is my understanding that they are still active.
Okay. All right, we're going to start with number 3. Is that okay?
Absolutely.
All right, look at the recommendation for number 3. Council, what is your recommendation for 3?
The written recommendation was for a letter of warning for violation of Tennessee Code 6239-421, and then a report to the appraisal subcommittee.
All right, you've heard the recommendation. Anyone want to discuss it or make a motion?
So this one is a different company? Same one?
Same company.
They're all the same. And in all honesty, I guess if we're going to take it as a package, because if you would like to look at the other recommendations, because that recommendation would subsume the first one, I think we could just do one recommendation for all four.
In reading through, I think we group them up because we're going to come to the one recommendation is my prediction.
Okay. So
go ahead and read the recommendations for all of them.
Okay. Yes, sir. So the recommendation of council would be that the respondent's AMC license be suspended for violation of Tennessee Code Annotated 6239-421, and that all matters should be reported to the appraisal subcommittee pursuant to Tennessee Code Annotated 6239-427.
Okay, and that's the recommendation from council for 3, 4, 5, and 6. Okay.
I get some clarification. If we vote to suspend their license is suspended effective immediately?
As soon as the meeting is over and we get them notice.
Can an AMC be fined rather than suspension? Of course, I don't have any money and not pay anybody, but
right. In this particular instance, it may not, they might welcome a fine just because then.
But my concern is if we suspend their license, they're out of business. Now, none of these appraisers are going to get paid. They may not ever get paid anyway. But if we suspend their license, they're certainly not going to get paid.
Well, that is true. As far as we know, okay. So you can fine them under the rules. You have the discretion to levy a fine between $50 and $1,000 per incident. So for 4 of these, you could do anywhere from $200 to $4,000.
I know. Also, we've discussed this before, but it's part of our licensing for AMCs that they have to get a bond. And the appraiser can go back on the bond if they don't get paid, which is good in theory, but I don't know how often appraisers really end up getting paid based on that, as opposed to what Kentucky does, and I know I've brought this up before, but Kentucky requires, and I know this is a legislative item, but Kentucky requires AMCs to pay into a fund that if the AMC does not pay, then the appraiser can send an invoice and proof they didn't get paid into the fund and then get paid from the fund so they don't end up being damaged because of that.
Huh. All right. We've heard the recommendation from council. Anyone wish to make a motion on what we're doing?
I'd like to make a motion that we accept that their license is suspended as well as a fine of $500 per occurrence.
All right. We have a motion that license be suspended from this AMC plus a fine of $500 per occurrence, which will vis-a-vis be 4 times 500. Do I hear a second?
No, 5, it says 1,000 is what they're saying that they owe. I don't know if
Okay, we have a motion on the floor. Do I hear a second? All right, motion's going to die due to lack of a second. We go back to council's recommendation that we suspend their license. Is that right?
Yes.
And notify the board.
The ASC.
Yeah, that's what I mean.
Will it be made public here in Tennessee for appraisers that may be taking jobs from them?
It'll appear on the disciplinary action report that comes out every month.
So appraisers should look at it.
Yes.
Okay.
In a case like this, is it out of line to say that something could be sent out in the interim? Does it have to wait till that, just because of the nature in which this operates? 30 days is a long time to potentially be accepting assignments you're not going to get paid for.
We could send out a press release or some form of communication from the appraisal board, letting licensees know of this disciplinary action. It might be easiest to do that via e-notify, which is our notification system. I don't know if you all are subscribed to that. We could do something like that, similar to that.
Before someone makes a motion to suspend, I'll try another motion. I just think suspension's like your last resort. Maybe we're there, but anyway, my motion is that we fine the AMC $1,000 per occurrence, $4,000 total.
Okay, we have a motion on the floor to fine the AMCs $1,000 per occurrence, which would be $4,000 for 4 individual occurrences. Do I hear a second?
I tried.
Okay, motion's going to die through a lack of a second. Open the floor back up for discussion. Maybe we need to add you two together.
Yeah, and that's probably where I was heading on this. This is a first go-around with the new AMC law. And especially with one like this that is covering multiple appraisers, I think we need to set a precedent from the get-go that this is going to be unacceptable in Tennessee. So the maximum we can do is $1,000 per case, and for a civil penalty. But I would make a recommendation of suspension and $1,000 per case.
Is that a motion?
That is a motion.
Okay, we have a motion on the floor and a second. We have a motion on the floor and a second.
Who seconded?
For a $1,000 fine for each case, which would be $4,000 plus suspension. We have a motion and a second on the floor, so we'll open it up for any further discussion.
So, Commissioners, just for the record, when you say suspension, did you have a time frame in mind, or until they completed an action, or what were you thinking?
Suspension, permanent, maybe a revocation or a revoked license.
Revocation?
Yes.
Instead? Okay.
So a revocation means that they no longer have a license with us. A suspension would mean that it is for a particular
Right,
time period.
yeah.
So if you're going to revoke someone, we would need a motion for revocation. If you're going to suspend someone, we would need a motion for suspension and the amount of time required.
In the recommendation, it didn't give a specified time.
I just wanted to clarify so you knew which one you wanted.
Yeah, I sort of looked at it as we're
It's more on the lines of revocation.
Yeah.
Since we're still in the discussion stage of this, since we do have a motion and a second on the floor, I would be in favor of what both Rex and Jason said, and that would be, let's put a 6-month time on the suspension with the anticipation that what Jason said, in the next month or so, we don't get 8 or 10 more of these coming back in from other appraisers that have not been paid, because then at that time we can say, okay, let's revoke it because you haven't paid, you're not going to pay. It appears that you might as well go ahead and file this bankruptcy that you're talking about. So I would amend the motion to say 6 months.
Who seconded the motion? I apologize. Thank you.
Further discussion from the commission?
Just one more point of clarification. So if the board takes this action, then the question would be, the typical process would be You all vote for, say, suspension for 6 months. We send them a consent order. They have 30 days whether to take it or not. If they sign it, then they're suspended as of the time they sign it. If they choose not to, then we would set it for a hearing, and then we would have a hearing. Or if you all think that it is egregious enough and important enough right now, we would have to tee it up for maybe a summary suspension, in which case, and I don't know if this board has done that before, but the UAPA has provisions for how we do summary suspensions. And so if you think the health, safety, and welfare of the people of Tennessee are endangered by this company, and you feel like you have to take immediate action, there's certain provisions that we can follow to do that. But I don't know if this board has gone down that road before.
I don't believe we have. That doesn't ring. We may have, but it doesn't ring any bells.
But we're in uncharted water.
Yeah, we're
now.
right.
Were you able to indicate if there are additional complaints?
My understanding is we do not have anything else as of right now.
Okay.
We have these in front of us right now.
Okay. As our legal, then, what is the advantage of taking this summary that you're talking about, of doing it that way?
So, summary suspension as for the health, welfare, and safety of the public. If you believe that this licensee is going to impact that, then we can summarily suspend them, which would take into effect immediately. But that's kind of an extreme end on that, and this particular case, based on the facts, looks like it is impacting the appraisers, the specific appraisers. So if you want to do that, I would want you to think about consumer harm here versus versus the colleague versus your industry.
I think it does. It impacts the lender. It impacts the borrower that will be impacted by this. As far as the length and time to go through the process of a loan, if there's an issue with an AMC, it will trickle down to the property owners.
One thing that we could do is, I think going along with, Commissioner Thomas's suggestion, what we could do is, you all had kind of on the table a vote for suspension. We can do the suspension. We can go ahead and get the letter out to them, and we can take a look on what is, send them a consent order, and we could keep an eye on if we get more complaints about non-payment, then we can always revisit it. You can always go get a summary suspension, because what would happen is, even if you voted for it today, we would either have to send them a letter that says you got to come back in 7 to 10 days and meet with us, so we'd have to have an emergency meeting, or you could suspend them right now, in which case we'd still have to have another meeting within like another 7 days, and then there's just several provisions we have to go through. But as of today, right now, if you all voted for this, we could get the discipline out to them, say, you have failed these things. We could send them a consent order, and then if they sign it, then we're done. If we get more complaints, we can always bring it back to you all, and we would have like an emergency kind of meeting, and just say, hey, we got more complaints, and now we got more evidence. We can go ahead and tee it up at that time. So either way, you're not really losing any time, depending on what happens down the road.
So it could be addressed before a July meeting.
Right, absolutely. If that is found to be, if we get more complaints and those kinds of things, we can 100% tee that up, with Roxana's approval and with you all's approval.
We could do a summary suspension even via teleconference, if that was the case. If this commission is of the opinion that it is harm to the public, not just the licensees, and has repercussions, then legal would find a way to treat it as a summary suspension, as long as it falls in that.
Or we could just revoke,
Yes.
and that would be the end of it.
But remember that the suspension, the revocation are going to take time if they don't sign on the dotted line. Then we're going to a formal hearing, which could be 3 months or longer.
And so if we suspended or revoked, could you still send out notification through the e-notification system? Or can you not do that until they sign?
So if we were to do that, we would have to wait 30 days until the notice of hearing and formal charges are filed. So we would have, like, if anyone were to request a copy of the legal report, they would see the commission's decision, whether it was suspension or revocation. But there's the caveat that that would not go into formal effect unless the consent order was signed or we go to a formal hearing. So if we were to send out notification, I think we would have to wait for 30 days for it to be like, this person's been suspended, formal charges are being authorized against them. But if there is a concern prior to, an individual can always submit a public records request for the legal report, which would have our decisions on there.
And how long does that normally take?
Following the meeting,
But it won't have their name.
it won't have their name, it'll have the complaint. So,
Will it have the appraiser's name?
no, so it'll be presented, the legal report will be presented just like it is here with the anonymous name, because it's anonymous until a formal discipline has been issued.
If someone were to look at that legal report and see that number, they could, if they asked us for the number, we would give them the complaint file, and that would have everything in it.
Yes, so they could ask for complaint number 2018-088271. I would like to have the complaint file, and then they would get a copy of the complaint, copy of the respondent's response, anything that's in there that we're allowed to give them. So they would have that information that way.
The only thing they wouldn't get would be like legal deliberations. That would basically be it.
So, I guess my question is, I realize we're here to protect the public, but are you telling me that my colleagues are not members of the public?
Nope, we're not. We're definitely not saying that.
Because we're having appraisers, I know that you're having appraisers probably take each one of these people aside somewhere and saying, what do I do to get paid from an AMC who's trying to screw me over? And that's kind of what I'm looking at now is, I totally understand we're here to help the public, but what are we doing to help appraisers who, I realize we can't get their money back for them, but I love this idea that he said about what Kentucky's done, and I think we need to look into doing something like this pool, but, what do we do to help these, or to satisfy or gives these fellas some kind of satisfaction that I didn't just waste my time, or you're wasting your time to turn in an AMC?
So, the discipline that you're going to recommend against the company in question would be an avenue that you would be like, because of this, we're going to suspend them, and we're going to fine them, or we're going to revoke them either way. It's just we're not allowed to, we can't immediately say something, because there are also due process concerns for the respondent as well, which is what we want to keep in mind. But they are absolutely part of the public. I just wanted everyone to keep those notions in mind when making those decisions so we can have a well-rounded, holistic conversation.
Okay. So at this point, we have a motion on the floor and a second to fine each instant $1,000 and to suspend the license at a 6-month period.
Yes, that's the current motion.
Okay. Is there any further discussion?
Technicality, since he mentioned the amendment, do I need to say I will
Would need to amend your
Yes,
motion.
okay. I do, because I don't want technicality to be an
Yes.
issue on that.
So as long as the person that made the motion agrees to the amendment and the person that agrees to the second agrees, when we can proceed with the motion. Okay.
Just making sure we're covered. So if you start getting, after this meeting, if you start getting complaints and they are pretty consistent, we can meet again.
Right,
Y'all
we can
will-
always call an emergency meeting, and those meetings, if it's by necessity, we can do that on the phone, call you all in, we can discuss then whether we would like to do something as a summary suspension. Absolutely. We won't have to wait till July.
Before we vote on that, while we're still in discussion, are you all familiar with what other states are doing? This is, I mean, we're in totally new water here with AMCs, with this board. So are you familiar with what other states are doing
With regard
to
to,
a situation that may or may not be similar to this with, I mean, because we're not, I'm not, I can tell you. So I just want to make sure we're doing the right thing at the right time.
unfortunately, I don't know what other states are doing at this point, but that's something maybe we could discuss at the Aero conference that's coming up soon and get some input from them. I could certainly ask the other attorneys what they're doing and how they handle these situations, but at this point, we don't know. So this would be an issue of first impression, but as always, we would like to learn and, refine for going forward. So if it were to come to, like, we get more complaints, we could come back and do the summary suspension, or we can just always, we don't want to necessarily do a presentation in July, but whatever you make, what you decide today, we can always bring back up again.
Yeah, Jason, I do, yeah.
I guess specifically, currently, there's an FTC investigation into the Louisiana Appraisal Board and how they inflicted fines on AMCs based on violations. I want to make sure that we are not in a similar position to what they are, and it turns into an issue for us, and it was specifically in relation to the fines that they were imposing.
Okay, so generally, when we have an action such as a suspension or a revocation, I would not recommend levying a fine as well, since a suspension or a revocation is impacting someone's ability to make a living. So I think probably what is happening there, FTC, we usually look at that for restraints on trade or entry into the profession. So if you were to do a suspension and a fine, that is a pretty serious recommendation, but you certainly could do that. Also, if a decision we were to make and we decided, looked back at it later and had some issues with it or some concerns, we could definitely bring that back before you again, because we don't want, like you said, the FTC to look into it. I don't think where we're headed right now with a suspension or revocation would bring us back toward that decision, but I don't know for sure. So if you were to do something, just keep in mind that suspending someone and fining someone, they are kind of counterintuitive, but I understand why you may want to do that. So just, I would recommend doing one or the other, but you can do both.
Okay, thank you. You all have very carefully listened to council's recommendation. We have a motion on the floor with a second that includes both a fine and a suspension. A fine and a suspension. I'd like to vote on that at this time. All those in favor of the fine and the suspension say yes.
Yes.
All those opposed say no. No.
No.
Okay, now I'm going to open back up. Brett? No. All right.
I would also just want to interject one more thing. We can, in a consent order that is sent out to the company, put in provisions asking or requiring the individual to pay back the amount that they owe the individual. And if they were to do that, then we could set certain conditions following that too.
That would be a condition that we're telling them they have to do.
If yes, but they also just want to keep in mind have the ability to either reject or accept that. So if they reject it, we go to hearing. But we could include that in a consent order.
Because I used to always tell my boards that at this stage you have more tools in your toolbox.
Right.
If it goes to a judge, there's really only a couple things you can do. You can suspend or revoke, or you can charge money.
Right.
But a consent order, it's basically an offer of settlement. So what we could do, if the board wanted to go down that route, I've seen it with other boards, is you could set a fine and say, if you pay these people back and submit proof that you paid what you owe, that would reduce your fine commensurately, or however you want to. I mean, there's more.
Sure. If they're in financial trouble, we need them to take the $4,000 fine and pay these fellows instead of
you'd rather
paying
them
the fine.
pay them than pay us.
Yes.
But if we're limited to $4,000 and they owe more than $4,000, then
Right, so that might not necessarily, be helpful if they owe more than $4,000 and then were to pay us $4,000, and who knows what else other financial issues there may be.
under the condition, can we suspend them until they are paid and then reinstate them?
That's possible. You can absolutely do that.
I like that. Yes, that's what I was going to ask. Okay, so do I have a motion?
I'll try again, yes.
Okay, the way I understand the motion is going to be, we're going to suspend them until they pay these individuals that they owe. We'll give them a 6-month suspension. And I don't really have a problem. If they pay the individuals back in 90 days, we'll lift the suspension at that time, once these fellows have been paid. But don't come, we don't want we want somehow to make sure they don't come back in front of us every month doing this.
What information do we get that they're still operating and in business? Where do we gather that information?
We have no information in the file to let us know that they are not operating.
We didn't do any research to make sure that they were or weren't?
Well, as of the filing of this legal report, we have, so if you look in the legal report, the attorney that did this entry did speak to someone at the respondent, and the respondent said, we're having some financial trouble and we're looking into filing bankruptcy. But as of, I think we turned this in on last Thursday. So as of last Thursday, there were no filings. We have access to the federal court system. There are no filings for this respondent. So they have not filed bankruptcy yet. So the only reason we were saying that we think that they might still be in operation is that they may not be accepting, giving out new jobs or anything like that, but they have not filed for bankruptcy yet. And so that's why that fact is in there. But they may not be active. That's fair. We don't know. But when the attorney spoke to them, they just said, "Hey, we're having some financial difficulties, and we're looking into filing."
And that's on
bankruptcy.
the legal report, the date of that?
Yeah, it said April 2019.
Yeah, as of this month before the report.
All right, go ahead.
Well, just a clarification, what would happen under this motion if they didn't pay at the end of 6 months? Is it still...
So that would be like a condition that you would put in the consent order. So you could say the individual has a 6-month suspension, or until the restitution is paid back to the individuals listed in the complaint.
Could we state that they have 30 days to pay the appraisers back, and at the end of 30 days, if the appraisers are not paid back, they're immediately revoked?
Because this is an offer of settlement, they could agree with that. Absolutely.
Okay.
We could send that.
Okay.
So I just want to make sure we have this correct. So we are offering them the ability to pay back the complainants within 30 days. If that is not accepted, then their license will be revoked.
They're suspended for the 30 day, up through, if they're suspended effective immediately until they pay the appraisers back, but they only have 30 days to do that, and at the end of 30 days, if they haven't paid them back, they're immediately revoked.
I think it would just be a revocation, not a suspension, because the suspension wouldn't go into effect, or the revocation wouldn't go into effect unless something was signed or we had a hearing. So it would be, we would draft a consent order, tell them to pay the individuals back, and if they don't pay them back within 30 days, it would be a revocation.
And they'll have to send us proof of that payment, right?
Yes, we'll ask them to
We'll
submit.
have language saying that.
Yeah, we'll have language to ask them to submit proof, and then if they don't either sign the order or pay the individuals back, we will file a notice of hearing and charges to be set before an administrative law judge.
So is that your motion?
Yes, sir.
Okay, the motion's been made that we do exactly what you said.
Okay.
Do I hear a second?
Second.
Any further discussion? All those in favor say aye.
Aye.
Any opposed?
Abstain.
Okay. Go to number, in legal, go to number 1.
Number 1 is 2017-08-1031. And as you can see, just so I know, just to sort of summarize, if that's okay, but the complainant alleges errors in appraisal resulted in gross overvaluation of 2 parcels of land. And then, as you can see, the expert review found several violations of use PAP, and so our recommendation, legal's recommendation was for, that's on page 3, legal's recommendation was for a consent order for 30 hours of coursework comprised of 15 hours of highest and best use courses, 15 hours of report writing. Such courses should be completed within 180 days of execution of the consent order, above, and the CE would be above and beyond the minimum CE required.
All right. You've heard council's recommendation on legal number 1. Is there any discussion?
Yeah, this individual's had 2 letters of caution prior to this. Is that correct?
Yes.
Yes.
Know what that was about? Or do we?
Based on the date, I don't believe we would be able to find them, but they were in 2007 and 2013.
Par for the course, every 6 years they get another.
My greatest concern on this complaint is, of course, the reviewer was very harsh, but every time, just about every paragraph, the information in this report is misleading and not consistent with value. The appraisal does not employ recognized methods. The appraisal, there is no rationale for support of the appraisal. The appraisal was not analyzed correctly. I mean, there seems to be a number of inconsistencies with this.
I have a question. On these reports, if a trainee has also signed on to that report that we end up reviewing, is there any mention at all of that trainee in any of this information?
I would assume that unless the complaint is against a trainee, that information would not be in the report.
The trainee has to be, according to USPAP, recognized in the report as providing significant appraisal assistance. They would not be responsible for the report unless they signed the certification, which I'm assuming they didn't, but they would have been recognized if they were involved.
So potentially the same person who filed this complaint could have had a lot to do with this report. Potentially. Okay.
All right, you've heard council's recommendation on number 1. What's the committee's pleasure?
just a comment before somebody tries to make a motion. 2 letters of caution, and the reviewer is saying that the report is misleading. It, to me, justifies a stronger penalty than 30 hours. If you want me to make a motion.
Please do,
I'll
sir.
make the motion to accept council's consent order of 30 hours as stated, however, with an additional $1,000 penalty.
Motion's been made to accept council's recommendation and add a $1,000 penalty to it. Do I hear a second? I'll second it.
One thing I would like to bring up in discussion, it appears this property and the appraiser is a certified general. The 15 hours of each probably lend themselves more to residential in nature as opposed to general in nature. And, and I looked up to do a highest and best use for general is 30 hours in itself, and for a report writing, it's 30 hours. So I would bump that up and make them take something that is more relevant to this and do 60 hours of education.
I can amend my motion to.
And I'll withdraw my second.
Withdraw.
You gonna?
I'll amend the motion to 60 hours, 30 hours general, highest best use, 30 hours report writing. Is it 30 hours report writing?
And no civil penalty.
With that, I'll withdraw the $1,000 penalty.
Okay, so now we have a motion on the floor for legal number 1 for 60 hours report writing and highest and best use. Is that correct?
Yeah, 30 hours.
30 hours
for
each. Yeah, 30 hours each, yes.
To be
Okay,
complete in 180 days?
Yes.
The rest, okay, great.
all right, that's the motion. Motion on the floor is for 30 hours, course writing, 30 hours, highest and best use. Do I hear a second?
Second.
Motion been made and seconded. Any further discussion?
Quick, I'm going to recuse myself from the vote.
Okay. Mr. Mansfield's recused himself from the vote. All those in favor, please say aye.
Aye.
Any opposed? Motion carries. Legal number 2.
Number 2 is 2018-07-5761. In this particular instance, there was a respondent AMC that has 4 outstanding invoices. And so the respondent, in response, claims that the payments for all outstanding invoices to the complainant were made by direct deposit on October 25th, 2018. All the invoices were from earlier in 2018, and they did provide proof of those payments. So legal's recommendation was a letter of warning on the requirement to pay promptly in Tennessee.
All right, you've heard legal's recommendation on number 2. That's on your iPad. There's a letter of warning. Hear a motion?
I have a question. Do we know, as of this is from October of last year? Do we know if the appraiser has been paid yet?
Yes, they provided proof of the payments. Sorry, it's the last sentence of.
Right, so our letter of warning is just going to be, make sure they stay on top of things.
Right.
Okay. All right.
And they provided proof that they did direct deposit?
Yes, sir.
Okay.
Is the letter of warning, is that the one that stays with their file, or is that?
Yes. So a letter of warning would be reported to the ASC. A letter of action would not be.
Motion for letter of warning.
Second.
Motion's been made and second for letter of warning to accept council's recommendation. All those in favor say aye.
Aye.
Any opposed? Motion carries. So where do we go? 7?
7.
Okay.
Okay. Number 7 is 2018 077301. In this case, there was a complaint that the respondent conducted an appraisal for cash-out refinance at the lender's request in October of 2018. Thereafter, the respondent failed to complete the appraisal because the complainant stated the respondent got into a dispute and refused to complete or submit the appraisal and failed to notify the complainant. If you scroll down, it says the respondent says that they were not aware of the particular loan or loan process. The client was informed of information not being sent to the respondent. However, the respondent was not willing to submit an appraisal. The respondent, the legal's recommendation was dismissal, as the respondent has a duty of confidentiality to his client, and it was incumbent upon the lender to notify the consumer of any potential delay.
All right, you've heard number 7. You've heard the recommendation from council on number 7. Any motions?
Was an appraisal ever completed?
No, it says he didn't do it.
Recommend to dismiss.
Motion's been made to dismiss. Do I hear a second?
Second.
Motion's been made and second to dismiss number 7. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries on number 7.
Number 8, 2018-077521. The complainant alleges that the respondent is manufacturing market trends and offering misleading data. The numbers on all of the 1004 MC forms are remarkably similar, and is alleged, therefore most likely made up. Complainant looked at 15 assignments in which all state 3 comparable sales available and 6 active listings. The respondent denies allegations, believes there's some confusion regarding his reporting method. The respondent states that when they analyze multiple sales and listings, respondent only includes the most comparable at the top of page 2 of the URAR. Respondent denies any wrongdoing. An expert review was conducted and found that market trends are not adequately defined or reported, highest and best use not properly summarized, sales not properly reported, sales comparison adjustments were not properly supported, the site value noted in the cost approach was not supported, the cost approach to value was not supported, and the final reconciliation was not properly supported. Let's see, so based on that, legal's recommendation was for either, as up to the board's discretion, suspension for 6 months for the above noted violations of USPAP contained in the single appraisal report, or a consent order for 45 hours of coursework comprised of 30 hours of sales comparison approach courses, 15 hours of report writing to be completed within 180 days of execution of the consent order. And then legal, the attorney that did this analysis said 15 hours of the sales comparison approach course may be used for CE. The remaining 30 hours must be above and beyond the minimum CE for license renewal.
Thank you. All right, you all heard number 8. I'll open the floor for discussion on number 8 or motions.
Who is the complainant in this? If they looked at 15 assignments.
Looks like the client.
Yeah, but is that who it was?
Yes, that's my understanding.
Okay.
I have a question. Earlier, when we were discussing with the people who were here, I saw one of the states required an appraiser to submit a log of reports to be, I guess, reviewed. Is that something we have the ability to do? No?
I think we just do that for trainees.
Okay.
Question, there are 7 conclusions on the first page there, didn't do the market trends, highest best use. Do we have the right to fine $1,000 per, for a total of $7,000? That per violation?
Yes, we do.
My thought here is this individual has an extended disciplinary history. They've already taken courses and already have been fined. Obviously, we haven't gotten their attention. Someone hasn't gotten their attention. I consider suspension for myself a very last resort. I don't want to take somebody's livelihood away from them, but I don't think education has helped this person, and we got to get this person's attention. So I will make the motion that we issue a fine of $7,000.
Motion's been made on number 8 for a fine of $7,000. No education, you say? I ain't gonna do no good anyway.
I got to get there. If $7,000 doesn't get their attention, then we're not going to get it.
Okay. Motion's been made for $1,000 for 7 infractions for a total of $7,000. Do I hear a second?
Well, they don't like the fining around here, do they?
Okay. Motion's going to die for a lack of a second. Let me hear another recommendation. The only question I have as far as your A on recommendation, suspension for 6 months, and of course, go back to what Mr. Atwood said, education's probably not going to help them anyway, but after 6 months, they just come right back into business and start right over? I mean, I guess our thought is maybe after 6 months, they become a plumber?
Well, I think at least part of the thinking was that, maybe it's sort of like the commission is like when my 4-year-old acts up, I give him time out. And I think that was the thinking of this is like, if you look, you know what, like you've got a lot of problems here. If you go and maybe do something else for 6 months, maybe then you will appreciate the opportunity of being an appraiser.
But if you wanted him to, or the person, I don't know who this is, the individual to not have a license afterwards, that would be a revocation.
Right, I understand that, yeah.
I guess, I don't know how that helps that person. I understand they've had 2 previous issues, but we don't really have, we have discipline, but we don't have any way that we're actually, if we want to try and make this person a better appraiser, how are we going about doing that? We don't have anything that says, hey, for 6 months you have to have all your appraisals countersigned by a certified residential appraiser, or for 6 months you got to send in a log to the board. The board's going to pull a certain number of random appraisals, and you're responsible for paying a reviewer to review the appraisals as part of your fine.
You could do that, but again, that would be by consent order, and that person would either agree to that or it would go to a formal hearing.
So same thing with the $7,000, he has to agree to pay it.
Correct.
He or she has to agree to pay it, or else we go to a formal hearing.
Yes.
Okay.
So all of our discipline, except the letters of warning and instruction, are offers of settlement.
Sure.
So if
Sure.
they don't settle, then we go to a hearing.
Okay. We have a motion on the floor for a $7,000 fine in this, no, we don't, I'm sorry. It died because of lack of a second. Okay, is there another motion on the floor, please, for number 8?
If we did a $7,000 fine that is forgivable, for a better term, if they comply with any additional items that we set forth, is that something that we potentially could do? If we said, you have a $7,000 fine unless you comply with these items. These items are, for the next 6 months, you've got to send a log to the board. The board can randomly select 3 reports. You're responsible at that point for supplying all the information and work files on those reports and paying for a reviewer to review those reports.
Right. You can do either or.
Both?
You can do both, or you
Okay.
can do either or. So they have the option of paying $7,000, or they can have there.
Try to improve.
Yes.
Okay.
I appreciate Mr. Bennett's desire to help someone, but I don't think it's the board's responsibility to babysit. I'll restate my motion of $7,000, see if I can get a second.
Okay, the motion's been made for a $7,000 fine, and that's it.
That's it.
Okay. Do I hear a second? I'm going to second it because I totally agree with him. I just totally agree with him. I think there's time need to get this person's attention. So the motion's been made and seconded. Now, any further discussion on that? All those in favor say aye.
Aye.
Any opposed?
No.
No.
Okay,
4 ayes, 2 noes.
yes.
Okay.
Okay. Now, this person has to sign that, right, that he's going to agree to pay it, or else we'll have a formal hearing.
Correct.
Okay.
In which case, if they decline the offer of settlement, we go to a formal hearing. They could lose it all. I mean, they could come here and lose their ability to work. So,
Right, that's okay. Understand that. All right.
My only concern is that there's still going to be appraising.
In the interim period.
Well, they pay the
Oh, yeah,
money and they
right.
go on.
Yeah, okay.
That's the part I have an issue with on that one.
All right, well, you have another one, number 10?
I think we're up to number 9.
Okay.
Okay.
I'm on the paper, you're on the screen.
Yeah.
Okay, go
Yes,
ahead, I'm sorry.
We're working together. Okay, so number 9 is 2018-077811. In this case, the complainant alleged that the appraisal was completed for a purchase transaction, and the respondent reported the contract details but did not offer reconciliation for those details. The final opinions and contract differed substantially with no reconciliation. Excuse me. The respondent believes that the request sent with a sales contract was not the subject property and that they were not supplied with the correct information. Respondent feels the complaint is an error. An expert review was conducted and found that overall the reviewer found the appraisal to be deemed unsatisfactory. General appraisal practices and procedures were followed. However, several USPAP rules or standards were not met. Several aspects of appraisal are subjective, however, compliance with the USPAP is not. Just to sort of short-circuit some of that. In summary, the report seems to unintentionally fail to recognize and adhere to the applicable assignment conditions, but still lacks competency. The appraiser fails to recognize and adhere to the conditions in developing this assignment, thereby violating the scope of work rule. Further, reviewer believes that submitted sales are not the best indicators of value, as they do not appear to be the most proximate recent sales. So to sum up, the recommendation for legal was for a letter of warning.
Discussion.
Okay, so it says the reviewer states that for the most part, adequate and relevant data is presented with the satisfactory judgment, logic, and reasoning being utilized and conveyed. It looks like the real question is comparable sales selection, which is the appraiser's opinion. And so I don't think that it's on us to be able to provide jurisdiction over their opinion when they're saying that no USPAP violations were made.
One thought I had on this one, the conditional CE that we have, there was no disciplinary history on them. We could just recommend maybe a sales comparison and a cost for the next CE cycle, and then it won't be on the record, but it may give them some guidance.
They would have qualified for that, you're correct.
So that would be.
Or the letter of instruction.
So that would be a letter of instruction telling them what we would like to see them do.
The conditional dismissal is continuing education, so they would have to take continuing education. It would not be on their record, and it could count toward their renewal.
Okay.
Or you could do a letter of instruction, which wouldn't be on the record. It's lower than the letter of warning, and the commission has said that wouldn't go on the ASC. we're inclined to dismiss. I mean, I don't want.
I just think a letter of warning is too severe because that's going on their permanent record.
Or education.
You could do education or letter of instruction.
I'll make a motion. I'll make a motion for a letter of instruction requesting those two classes in their next education cycle.
No, they're too.
So that would be
Yeah.
dismissal.
Yes.
So like a letter of
Oh, I
instruction
gotcha.
would be like, hey, don't do this. You feel like, maybe you can instruct them about the different rules.
What have you entitled that?
The letter of instruction?
No, this next thing you just said. What do you?
Conditional dismissal.
Okay, yeah. Okay.
That would be where we require them to do certain courses and it would count towards their continuing education.
It would count.
Yes.
Okay, yes.
And then just a letter of instruction would be like, please keep these things in mind as you continue in your career.
I interpreted that as within the letter of instruction that we say, hey, you should probably look at these classes, but we're not monitoring that.
Okay, so we want to include in the letter of instruction, when you do your CE cycle next time, maybe take these courses.
Exactly.
Okay, we can do that.
All right, we have a motion on the floor.
What are those courses?
Sales comparison and cost.
Okay.
And I second that motion.
We have a motion and a second on the floor for a letter of instruction that includes sales comparison and cost education. Any further discussion? All those in favor say aye. Aye. Any opposed? Motion carries.
Before we go forward, is this on? I would like to question the reviewer of this particular, the one we just voted on. It seems he or she seems to be talking out of both sides of their mouth at the same time, and there's not a single USPAP violation enumerated. This appears maybe to be a reviewer we've not seen before. I don't know who this is, but you know, I have complained in the past about reviewers not doing the proper review work, and I would complain on this one. So whenever you use this particular reviewer again, they need to be a little bit more specific and a little more consistent in what they say. This was a very confusing review report to me.
All righty. Number 11, is that right?
Ben? On the paper, number 10, 2018.
Okay, no problem.
2018-080611. This one was just the complainant alleged respondent did an inspection at the complainant's mother's house. The respondent the respondent went into the attic and broke several stairs, and then the respondent agreed to pay for the repair of the stairs. So we just wrote it up as a dismissal.
So moved.
There you go. Second. Motion been made, second. All those in favor of council's recommendation to dismiss, say aye.
Aye.
All right. We don't appreciate them talking about them fat guys that are appraisers. I'm just going to tell you.
Hey, it happens. It happens. Man of stature. Okay. Number 11, 2000 on the paper. Number 11, 2018-060451. This complaint boiled down to a miscalculation of the gross living area of the home. The respondent says that they switched measuring methodologies, and so they were just off. The expert reviewer found several violations of USPAP. The important thing to note is that they said that the council that they said that the several of the violations of USPAP were the result of the miscalculated gross living area. So based on the fact that council does not believe that the property size error was intentional and that the respondent has not had any action taken against them, was recommendation of a letter of warning.
All right, you've heard council's recommendation on number 11. Any discussion?
There was a letter of warning in 2007.
Right. Yeah.
Okay.
So this is a second complaint.
Yeah. Since 2007, I misspoke. Sorry.
Pleasure to commission.
So the reviewer actually measured the property, is that what that says?
Yes. And
Found a discrepancy of 700 square feet. Well, this is a prime example of where what might to somebody be a simple mistake has resulted in an aggregate, multiple mistakes that render this appraisal destroying its credibility and rendering a misleading report. I think it's more important than, what is your recommendation?
a letter of warning.
Yeah, I don't know. We're going to make him take a course on learning how to measure a house. I mean, I don't know. But I find this to be, to me, I think it's a little more significant than a letter of warning. But I don't know what.
I guess just one point. All the use PAP violations mentioned are in regard to the gross living area miscalculation. So, it talks about in the sales comparison approach that the subject, that the gross living area was miscalculated. The same thing within the cost approach. So it seems to be kind of one similar issue throughout the reviewer's conclusions.
That's my point.
Do we offer a course on measurement?
No, well, I don't know. But my point is, one mistake has led to multiple mistakes and a misleading report.
Well, it's not even, it sounds like he knew how to measure a property until he switched to new technology.
All right. Recommendations? You've heard council's recommendation. Do you want to deviate from that?
I would, but I don't know what to come up with.
I thought we had.
I was hoping somebody else
I thought
was.
there was like a 4-hour measuring course.
There's an ANSI course.
Well, isn't there some kind of a course on measuring?
I've never seen it.
I was thinking I took a 3.5-hour course one time on measuring.
I think he knows how to measure houses.
I don't think that's his problem.
I think you could probably make that claim with any residential appraisal. I think you're kind of opening Pandora's box there.
Can we say a strong letter of warning, which includes, I'll make the recommendation that we give them a letter of warning, but the letter of warning should include the making of one mistake leads to multiple additional mistakes, which creates a report that is misleading. That kind of language needs to be put in there that he needs to guard against in the future.
All right, motion's been made for.
Also, just in case there is, we have one course that's called home measurement that's available.
All right.
To do that.
We have
Probably online, and how do you learn
can't
how to
tell, but
measure a
it's
house
7
online?
hours, so I'm not sure if it's.
All right, we have a motion on the
Yeah,
floor
it's internet.
to present a letter of warning. Do I hear a second?
Second.
Motion been made and seconded for a letter of warning on number, on my phone, number 11? Okay. All those in favor say aye.
Aye.
Any opposed? Okay. Number 12.
Number 12, 2018-062301. This one was the complainant alleges unlicensed activity on a mass nationwide appraisal where multiple cell phone tower property was appraised. The review showed approximately a dozen cell phone towers listed in Tennessee. Let's see, the alleged appraisal report was provided to the expert reviewer, and it was included over 1,000 pages of supporting documentation. The expert reviewer found that the alleged appraisal report constituted a fair value report with no association to USPAP. Accordingly, the expert reviewer concluded the report is not a USPAP report, despite being signed by an appraiser licensed in a state other than Tennessee, wherein assistance was certified as being provided by a Tennessee licensee. The expert report reviewer concluded his review by finding that this report is a disservice to USPAP as well as an appraisal report of real property as defined by market value. Although the report is disguised to represent a market value appraisal report with respect to its construction and included USPAP definitions, its clarity is deceiving. The attorney that did this review wrote it up as a dismissal.
I'm not getting that as far as the dismissal. And from my understanding, if they're operating in the state of Tennessee without a license, it's not under our jurisdiction, but it shifts over to the Attorney General for criminal. Is that, I think that came up in earlier meeting, but if they're operating without a license, it shifts to the Attorney General.
Another thing you said was, you made a comment, and I guess I misunderstood it. An appraiser from another state signed it? Well, that doesn't carry any weight in our state whatsoever, does it?
Right. So my understanding is that this involved thousands of, it was like a nationwide, basically like appraisal.
Yeah, and they occur daily as far as going across the state, and you have to get a license in that state if it's a mandatory state.
Right. And so my understanding was that the person in charge of the whole thing was not licensed in Tennessee, but they had an assistant or they had someone licensed in Tennessee that said, "Oh yeah, I did those appraisals," and I think that they signed it even. Was that right?
I don't think that's what it stated. You know.
Yeah. Let me see. Okay, one of the individuals received a temporary license from the commission for the purposes of this transaction and later became fully licensed in the state of Tennessee.
But a temporary license is property specific, so they would have to get a temporary license for every property that they did.
So unlicensed cases don't have to go before the Attorney General. It may be considered a misdemeanor, but what we would do in an unlicensed case is send the individual a consent order of some kind with whatever discipline that you offer, and if they do not accept it obviously would not be education because they're not a licensee. If they do not accept it, that would be sent to a formal hearing, and that would just be before an administrative law judge, not before the commission. It would be ALJ judge alone.
Oh, this is an appraiser who's licensed in another state, signed this report, and put his credentials on there. And we're saying in the reviewer says it's not an appraisal? Am I understanding that correctly?
That's my question.
Well, let me ask you this. Do we know what other state he's from? Well, not us, but you all.
We know that.
Okay, is it, instead of dismissing this, why don't we send this to them? And say, you got a guy doing something that he shouldn't be doing, using your license in our state.
We can, but it's a jurisdiction issue.
Well, but I also understand that if this person is unlicensed and you send them a letter, if the Board of Pharmacy sent me a letter that said I'm not allowed to give somebody aspirin, I'd probably just throw it away because I really don't care. They don't have any jurisdiction over me. So if we come up with some kind of action, they could just say, you know what, I don't care what those guys say.
Right, that's fine, and they would still go to a hearing, and that individual would still be liable for a civil penalty. So we could.
Oh, he would be liable for a civil penalty.
Absolutely.
Okay.
Because they violated our rules and statutes. So we could refer this matter to the appropriate jurisdiction for their review, but also, since this happened in Tennessee, it's in your jurisdiction to, in this instance, it would be a civil penalty.
How about it says, assistance was certified as being provided by a Tennessee licensee. Did they not sign the report? How was it certified?
We can pull it up in let me pull that up 1 second. Also, if there is, if you notice that another licensee certified something that they should not have, you have the authority to open up an administrative complaint against that Tennessee licensee if you would like to.
Just my question potentially is, did they pay a bunch of appraisers in a bunch of states to do these appraisals, and then this gentleman basically just compiled an analysis of that?
Second, I'll pull it up.
Do we have, and this is just a question because I really don't know, do we have the right to send a cease and desist letter?
For unlicensed activity, you can tell, because there's state law that says you have to have a license to work in Tennessee. So
I would think that's what we need to be doing, is sending these people, you don't come in here and do appraisals unless you have a license.
They don't have to have a license in Tennessee. We could still, if they're an appraiser, correct, and have a license under another state, then we could still issue something. Yeah.
Not licensed here.
So it looks like the review says this is a fair market value report, and not. Okay, so it looks like for this particular complaint, there was a mass valuation of assets in 48 states, including Tennessee.
Okay, do we know anything about the assistance was certified as being provided by a Tennessee licensee?
So it looks like there we have an individual with a temporary practice permit, but that temporary, and then they were permanently licensed in another jurisdiction. Let me see if this is a Tennessee temporary permit. All right, another state. Okay, so the individual, the person that had the temporary practice permit, they had one with our state that expired in 2017. The effective date of the appraisal report was July 2016. And the date of the appraisal report is February 2017, when that was delivered to the client. So they had a temporary permit license at the time of the report.
Doesn't a temporary license is property specific? It's for
That's correct.
not project specific, but property specific.
Yes. So for that person, if you were to want to take action, we would need to open a separate complaint against them, and it's in with your purview to do that.
Do we know who the client was and the intended, the intended use of these reports?
We know who the client is and the intended use. Yes.
Are you allowed to tell me what the intended, any of that? Can you just say generally who the client was, like a bank or a individual or something in general?
This was for evaluation of cell phone towers, so the client was a cell phone company.
Utility.
And the intended use was for that client to
market within the different states. It was conducted over 48 states, including Tennessee.
So it's like fair property.
fair value.
Yeah.
Go ahead.
Well, it's more of an accounting terminology than anything else, and not appraisal. It sounds like whoever got the temporary license is who they were trying to cover the basis of doing the valuation towards a real estate. So it's that person who we need, and they did not sign the report?
Okay, you want to break? Okay. Don't care about you, Jason. Just kidding. You've been married a while. You're used to being abused, right?
Oh, dear.
So, could we, are they referenced in the report? Are they referenced as far as,
Expired licensee.
yeah, the temporary?
It would be in the certification where it's supposed to be, where it should be.
It sounds like there probably isn't a certification. I've run across accountants doing valuation that are not licensed, and they try to hide behind stuff. Had one a couple years ago, and I talked with Sarah about it. But this is a little bit different because an appraiser did it, and an appraiser should know better.
I don't see a certification in this report.
I ask a question on how would potentially how is this different than an evaluation?
An evaluation can only be done under certain situations, and it's specifically stated.
Being specific, okay.
Exactly, yeah.
But the certification
sorry.
wise, if he signed it, we discussed this during that process. If he signed it as an appraiser, it's an appraisal.
Right, so I found the certification. It was this is over 100 pages, sorry. I found the certification, the individual's name is signed, and the person who had the temporary permit license here, it's listed as assisted by, and their name is there, but there's no signature. It's just.
And it doesn't reference their license number or anything like that. So there's several issues there. We'll be going down a rabbit trail if we go discuss that, because this isn't in the realm of an evaluation or anything like that. And it was presented as an appraisal report based on the reviewer.
Right, it says real property appraiser certification.
Two things. We could go after the temporary license holder and then pursue the person that did sign it. And am I correct? We can do both?
Yes. You could issue a civil penalty for unlicensed activity against the individual that signed it, and then we can also you can authorize us to open an administrative complaint against the expired temporary licensee individual.
Okay. Is there a limitation on the civil penalty?
$1,000.
That's what I thought.
How long is the certification? How long is it?
One page.
I hate for you to have to read the whole thing, but could you start reading it so we know what he certified?
Sure.
I'll stop you if it gets too lengthy, but I'd
Okay.
just like to know what he certified.
His name is.
Okay. We certify to the best of our knowledge and belief the statements of fact contained in this report are true and correct. The reported analyses, opinions, and conclusions are limited only by the reported assumptions and limiting conditions and are and are our personal, impartial, and unbiased professional analyses, opinions, and conclusions. We have no present or prospective interest in the property that is subject of the report, and no personal interest with respect to the parties involved. We have performed no services as an appraiser or in any other capacity regarding the property that is subject of this report within the 3-year period immediately preceding acceptance of this assignment.
Could you skip and see if there's any statement there? I don't need, that's a typical use PAP. That's a typical certification, if there ever was one. Is there a statement that says we complied with use PAP?
Here's our analyses, opinions, and conclusions were developed, and this report has been prepared in conformity with the most recent edition of the Uniform Standards of Professional Appraisal
That is an
Practice.
appraisal report. That is not a fair market. I don't know what fair market value is, but that's an appraisal report. It does fall under our jurisdiction, and they have violated.
Well,
It does fall under our jurisdiction as an appraisal, but they are not licensed. Therefore, it would be like we would have a $1,000 civil penalty for unlicensed activity.
That's all we can do.
You could,
12 times. How many properties?
Well, that's
Well, I will look and see how many properties, and let's circle back. We could do it per instance,
Yes.
and let's, for the sake of time and everybody's effort.
I thought you said 12 a minute ago in Tennessee.
Approximately a dozen.
Okay, approximately.
So I'll get the exact number for you while we go to the next one, if that's okay.
yeah, be fine. Okay, we're going to move, we're not going to make a decision on number 12, or is it 13?
It's 12. So we'll come back.
Okay, we're coming back to 12.
Okay.
Go to 13.
Number 13, 2018-084581. This complaint was lodged by a Tennessee real estate agent. Basically, the complainant says that the respondent was rude and demeaning, and they called them an idiot. And so the respondent admitted that they called the complainant an idiot, but says that's because they told him the same thing 6 different times. So
Sometimes you got to call them like you see them.
That's a recommendation was to dismiss.
Okay, recommendation is, number 13 is to dismiss. Is there any discussion?
Motion to accept.
Okay. Second. Motion's been made. Second. All those in favor say aye. Aye. All those opposed say no. Okay.
All right, number 14, 2019-002-741. In the interest of time, I'm going to kind of skip around on this one. This one was pretty long, but basically the report. So the complaint was filed against a respondent who conducted an appraisal in Belfast, in a different part of Tennessee. The complaint alleges the respondent's report is not adequately supported by the data in the appraisal report. And so if you would come along with me, like on the next several pages, the expert reviewer found multiple violations of use PAP. And then, so then if you skip over to the attorney's recommendation was for, and I think that was a typo. So it should say legal counsel recommended 15 hours of coursework, courses to be decided by the commission. Such courses must be completed within 180 days, above and beyond the minimum CE required.
All right. You've heard council's recommendation on number 4. Is it 14?
Yes.
Number
on
14.
the paper, number 14.
Okay. Number 14.
That's real long.
Anyone wish to make a recommendation? Motion.
Well, okay. Has disciplinary history of a consent order in 2006, so this is not the first offense. And there is a long laundry list of use PAP. I don't know where to go with it, though. I don't think that's a sufficient, the recommendation, I don't think is sufficient. Somebody else come up with something for a moment. Let me ponder it.
Jason?
I would agree that based on the use PAP violations, the recommendation is insufficient.
And your recommendation is?
What about 15 hours of coursework?
Test.
Well, I'll go ahead. I would make a motion that we require a 30-hour sales comparison course, 15-hour report writing course, and if you want me to add the 15-hour use PAP, I don't know. You want to do that one? And the 15-hour?
I think a 15-hour use PAP with a test is this individual needs it. All right, so the motion is
30 hours.
30 hours sales comparison, 15 hours report writing, 15 hours use PAP with a test. Do I hear a second?
Second.
Motion been made and seconded. Any further discussion on number 14? Yes. Okay. All those in favor say aye.
Aye.
Any opposed? Motion carries. Number 15, please.
Last one, number 15, 2018-091971. This was another AMC for failure to pay timely. The respondent admitted that they did not pay timely. They had no good reason why they had not done so, and that they introduced proof that they paid on January 4th, 2019. So the recommendation was a letter of warning for their failure to pay timely.
All right, but they have paid it.
They have paid.
Okay. You heard council's recommendation on number 15. Anyone wish to make a motion or discuss it?
Based on our prior one, I move we accept
Okay, motion's
council's
been made.
recommendation.
Motion's been made and second to accept council's recommendation. Any discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries. Thank you very much, legal.
Well, we got to go back to 13, right?
Oh,
12.
12.
Back to 12.
that's right.
I mean, if the board would be allow it, we could fill in the number later. If you wanted to authorize $1,000 per instance in the state of Tennessee, we could then figure that number out, so you all don't have to wait for us, and then we could put that into the consent order.
All right. Do I hear a motion?
I make a motion that civil penalty of $1,000 per property in the state of Tennessee, and open an administrative review of the individual holding a temporary license.
And that's number,
Administrative complaint?
Yes.
yeah, and that's number 12, right?
Yes.
Yes.
Okay. Motion's been made on number 12 for $1,000 penalty per incident or per property, and then open a administrative case against the temporary licensee. Do I hear a second?
Second.
All right. Any further discussion?
Just a question. If this is 10 or 15, that's $10,000 or $15,000, but what if it's 50?
Then they split it with us.
Do we want to limit, I'm just asking the commission, do we want to limit that to a certain amount? We don't want to go up to $50,000, I wouldn't think.
We just heard this other gentleman had a $46,000.
Yeah, it was a large project.
But they weren't all in Tennessee.
Right.
But these were.
But the only ones we're going to find.
This would just be for
are the ones in
Tennessee.
Yeah.
Tennessee.
I understand, but do we want to limit that, or maybe we don't? I mean, if you don't, we don't.
That's the whole point of it, hitting
Okay.
each one.
Okay.
They should have known better.
All right, motion's been made and second, $1,000 per incident. Any further discussion? All those in favor say aye.
Aye.
Any opposed? Motion carries. Thank you, legal. Appreciate you putting up with us.
They're not quite done, but yeah, they're done with it.
Where do we lack now?
So the next thing on our agenda is the legislative update. That starts on your iPads on page 50. We have two bills before you. These were emailed
Right.
to everyone. I don't know if you've had a chance to look at them, but either Anna or Denard will kind of brief us in. And neither of these two bills are specific to the industry. They're general bills that impact regulatory.
So I'll try to be brief, although this is a pretty hefty bill. But there is a bill that is moving through the legislature. This one is Senate Bill 196, and basically it would be an update or a substantial change to the Right to Earn a Living Act. And so it would change, if enacted, would change many of the ways that we, as a department, this is a department-wide bill, would change many of the ways that we license folks who want to come into the industry in Tennessee. It would involve limitations on the boards and commissions' power to set entry regulations. This bill would limit that power pretty substantially. Certain occupations are excluded. The version that I've seen, I think the Board of Accountancy is excluded, and then like the health-related boards over at the Department of Health. But everybody else with the Department of Commerce and Insurance would be affected. And so basically it says that one of the proposals would say, for instance, all entry regulations with respect to professions are limited to those demonstrably necessary and carefully tailored to fulfill a legitimate public health or safety objective that cannot be effectively served by restrictions that allow greater private participation. Now, you know, this is all written by lawyers, so we're not 100% sure how that would work in practice, but we are pretty sure that it would substantially change the way that we operate. It would also allow people who aren't in favor of the boards and commissions regulations to petition the department to change those laws or rules. And so, like I said, it's a lot to kind of take in. Right now, it's still at the proposed stage. It's been bandied about. There's a lot of amendments and those kinds of things. But just the bottom line, it would be kind of remains to be seen whether this is going to be enacted and what the real effects would be. But it would possibly substantially change the way that we conduct our regulating of the professions.
You anticipate this being voted on this year?
No, I defer to Roxana, but I think that it has gone around the bend many times. There's been a lot of amendments, a lot of amendatory language, and so I think that it probably will get a hearing this year.
The Senate bill number?
SB 196.
And Randy, I believe I emailed those to you. These are lengthy to read, so you all did get them by email. On your iPads, that one, the Right to Earn a Living bill, is 57 through 79. It's the second bill that's there, yes.
Okay.
The second bill that we have before you is another one that would affect the various regulatory boards for Department of Commerce and Insurance, and that deals with a licensure for members of the armed forces and spouses of the armed forces. Several bills have been circulating concerning licensure. These bills would allow a person that has a valid license to practice in the regulated profession to be issued a license here with our state, as long as it they're in good standing and they respect the harms or violations of the statutes, and they register with our agency. So this would just kind of be like something similar to reciprocal licensure for military members and their spouses if they are stationed in the state and currently licensed in another. Does anyone have any questions concerning either of those bills?
Want us to take some kind of action? Or just some information?
These are just for updates
Okay.
to let you know of certain bills that don't necessarily target your board, but if passed would impact the Real Estate Appraisers Commission.
Mr. Button, you have something to say?
Yeah, on this Senate Bill 196.
Yes.
On the Senate Bill 196 and House Bill 261, it is moving through committee. The one, we've had some conversations, I've also had several conversations with the Deputy Commissioner here at Commerce and Insurance. The one concern I think we would have for appraisers is that we do have federal mandate requirements that the Appraisal Subcommittee has for our entry, education, experience, testing, those kind of things. So this was concerning to us, just that this is an extension of the same bill that was passed, I think, 2 years ago. The first this is like right to earn number 2, Act number 2. But there is some support in the legislature for this, and so there are some concerns. Now, speaking with the legal counsel of the folks that have brought the bill, they've said that this would not impact any federal mandates that are out there now. But there is somewhat subjective and questionable how this could affect this particular board. And I think the departments, I'm not speaking for the department, but I think the department is opposed to implementing these further restrictions.
I'm not, I cannot confirm nor deny. I think at this point, we are, the official position of the department is that we are deferring to the will of the legislature and keeping an eye on it, as we would. But I can't speak for the commissioner or the deputy commissioner on that point.
And I'm not here to speak for them either. I'm just saying that there is some concerns because it is talking about barriers of entry into a profession. We do have some mandatory education and experience requirements that we do have in place, and we have to be able to be to be in compliance with any federal related transactions. So I've spoken also to the bankers who have had some concerns as well about this legislation.
Oh. One more thing for everyone. So if you'll turn to page 80 of your iPads, you'll see rules. So our rulemaking hearing notice is currently with the AG's office. It's in pre-review status. Since we have last met in January, Executive Order Number 5 was passed by Governor Lee, which put a freeze or a moratorium on rules being filed with the Secretary of State's office for 90 days. So our rules have been moving through the channels, have been approved by the department. They're at the AG's office currently. And then we will send them to the, once those are approved, we'll send them to the governor's office. But we're not allowed to file them with the Secretary of State until the 90 days is up, which is should be soon. So there is going to be a little bit of that, but that's across all executive branch departments. The rules before you may look familiar because the notice of rulemaking hearing rules also amend this section as well. As you know, in January we had an audit by the Appraisal Subcommittee, and one of the areas in the audit finding was an issue with our registered trainees rules. So if you'll turn to, it's listed as number 7 on the document, and that's page 86 of your iPads. This is the substantive change of the rule. So the rule would deal with the supervisory requirements for registered trainees. So our rule currently said that a supervisory appraiser would have to accompany a trainee until they have completed 500 hours of acceptable appraisal experience. The rule needs to have language in there that addresses 500 hours of acceptable training experience, or if the individual is competent as provided in the competency rule of USPAP. So we wanted to go ahead and clarify and add the language in blue. So it would say, or until the supervising appraiser determines the registered trainee is competent to inspect the property in accordance with the competency rule of the Uniform Standards of Professional Appraisal Practice for the type of property, for the type property. There are some other changes in this rule you'll see here, but those are mostly just edits that I received previously from the notice of rulemaking hearing edits from the AG's office. They aren't substantive, they are just rule cleanups, such as removing January 2015 because that's already passed. So I suggested to and consulted with Roxana that we go ahead and move these rules as proposed versus the notice of rulemaking hearing, because this is something that we have to fix as been identified by the appraisal subcommittee. Also, with these rules, you'll see that I have attached the regulatory flexibility addendum and the impact on local governments and the additional information as required by the Joint Government Operations Committee. So those answers will go to them as well. And I just wanted to know if anyone had any questions about any of those statements or anything about the rules in general.
On page 81,
Okay.
section E,
Yeah.
removed approved. So what does that mean? Can anyone teach that class now?
No, it would just be the 30-hour courses that we have listed. That wasn't an edit of mine. That was an edit from someone else reviewing the rules. They just thought that approved 30-hour course was redundant because we would not approve a non-approved course. That sounded redundant as well, so I apologize. But if you would like, I can keep that language in there as well. And also, there are other parts of the statutes that, part of the rules and statute that address the specific 30-hour courses that have to be taken. So
this is covering our basis, and then as far as the rulemaking hearing that we'll have will occur somewhere in the future?
yes, so this is for the change to the competency rule to add that in there for the 500 hours. And it's separate and apart from the rulemaking hearing required with the CE and qualifying education courses being distance education. That's a separate one.
Does the ASC have jurisdiction over our proposed rule changes, and did they make any suggestions, or they're letting that go?
So they gave us they told us what needed to be fixed, and so we did the proposed rules based on that. And I think we've also, once we got that, we turned it around real quickly, let them see it. We can also send that by our, send that to Jenny Tidwell and let her look over it. But as far as we know, this would address the issue that the appraisal subcommittee showed us.
So the rules that are yet to be dealt with have not been changed since we have seen them.
They have not been changed substantively. There are some minor edits as far as changes like removing January 1st, 2015, those kind of things, but the substance of the rules has not been changed, no.
Cleaned up.
Just, yeah, some further cleanup as suggested by the AG's office.
Question.
Sure.
On page 86, the language that was added, is it safe to assume that the inspection, they're considering the inspection part of practice?
Inspection.
Talking about the trainee has to be competent under use PAP. So we're considering that part of appraisal practice, the inspection.
So, this language was basically taken verbatim from the competency rule that was listed in USPAP and verbatim from what was outlined in the audit document. So I just kind of copied.
They submit anything to us as far as their competency to go out on their own, or is that just at the sole discretion of the supervisor?
The sole discretion of the supervisor. If they read the rule and believe that the trainee is competent based on USPAP, then that is fine. We just needed to make sure it was absolutely clear in the rules that that was a requirement beyond the. So, if that is, if you are okay with this, we'll need a roll call vote.
Okay. Tell us what we're voting on.
We're voting on amendments to Rule 1255-01-.12, which are the rules for registered trainee.
Ma'am.
Do we have a motion to agree to the rules as Anna has presented them?
I'll make the motion to accept.
Second.
Motion been made and seconded. Taking roll.
Thank you. Mr. Randall Thomas?
Yes.
Mr. Rex Garrison?
Yes.
Mr. Jim Atwood?
Yes.
Mr. Jason Bennett?
Yes.
Mr. Brett Mansfield?
Yes.
And Ms. Michelle Alexander?
Yes.
Thank you.
That is all from legal.
All right. Thank you.
Thank you, legal.
All right, and we will try to, I know you all are starving. I am sorry we've lasted so long. To stay in line for just a minute with the rules that Anna worked on, she prepared these while the auditors were here so they could review them. So I've got their 2 letters. They audited the appraiser program as well as the AMC. I will keep it short and simple. They found 2 laws that were not in compliance with the way their laws read, and as you all know, we don't have any control over the laws. We do the rules, so we jumped on them. So we responded, and to the best that we can, we will obviously kind of encourage that these be made correct, but we can't control that. Separately from that, the other 2 items they noted we believe are minor. 2 letters of warning were not properly added and timely added to the registry, and 1 letter of instruction was then shouldn't. We were kind of in that pool of not being consistent with adding those, and then we did have a course that had a secondary provider properly noting the relationship with the secondary provider. So responded to that. Hopefully by the next meeting we'll kind of let you know, I, like you all, probably wanted to get an excellent rating, and the laws and rules that have been in place could have been caught, I guess, before. It's one of those things that this audit, we'll move on those and keep you posted. Sounds good?
Still got a good rating.
Well, we hope so.
Oh, we hadn't got any rating yet till that's cleared up?
That's correct.
Okay, thank
That's
you.
correct. We will, we've responded and hope to get something in writing here soon. On your iPads, we'll go through the budget and any questions that you have, and I'll get you a page here in just a minute. A quick summary on numbers for you to look at, and that's because we'll be doing a presentation here on April the 29th. So on your iPads, on page 110 is the budget. Let me know if you've got any questions.
Fine, you're going to be doing a presentation on the 26th or something.
On April the 29th, I am going to, you can tell I've got too much stuff. All right. Do an outreach at that time, and it is to the Appraiser Coalition. It's over in Lebanon. The tournament is a golf tournament to the Tennessee Appraisers Coalition. It's April the 19th at 5 Oaks Golf Course and it's I believe they're doing some continuing education credit, and wanted me to speak on behalf of the licensing piece, what we're seeing an increase of, things that the office are finding. I think I've done a couple of these in the past. So the financial information before you, that's not necessarily of interest to them. This piece on page 110 is for you to see. I think we're in line now that the bigger months of expenses have come through. We don't have a ton left over, but we're at $368 for the fiscal year. But I think our numbers now moving forward, and that's just through February, will be okay. The following page has a breakdown of expenses, and then I've listed what I plan to present at that April meeting, just to give you an idea and give them an idea of our licensing numbers. This tends to be what interests when we have conversations. What are we seeing an increase in? So based on the graph on page 112, we have a total of 2,105 active licensees, and I have them broken down by licensed, residential, general, and then also wanted to give you our trainee numbers. So we've got, you can see that the general has gone up, and that's the average number of new people that we're seeing each year, and we've been lumping them by 5-year increments to kind of have an idea of what we've got going on. The next page looks at our Tennessee residents that are licensed. So of all those 3 different license types, we have 1,881, and you can kind of see of the Tennessee residents what the numbers for each category are, and that's March 19th. Our trainees are at 223,000, and so the next page lists those, and this kind of falls in line with the financial institution gathering that several of you are involved in, and looking at the licensed individuals throughout the entire state. This just reflects our trainees that are coming into the industry, hopefully, but they're based on East, Middle, and West Tennessee, to give you an idea of what's coming. That's 223 individuals total that we have. Temporary permits, we have 148. Those vary immensely since they're only good for 6 months. The only other thing I have, any questions on this information?
Can we get a copy of this?
Oh, yes, I can email you these numbers, absolutely. We have the Aero Spring Conference that several of you are going. Anna's going as well, so that's coming up. Hopefully you've got your reservations and everything else for that. And I don't think I had anything else other than to mention the April presentation. And then, Rex, you did print out or send me, kind of after I'd emailed everybody, under new business, I've got an update of the joint efforts with the financial institutions for you to, I think everyone has a paper version on your desks.
This is, we had a conference call Friday. It was Colin Barrett, president of the Tennessee Bankers Association, Ted Williams, president of TriStar Bank. And this, what you see is probably the closest we've gotten to an itinerary for schedule. We're going to try to get it hammered out by mid-May. We've got a few things. I'm following up with John Brennan, jumping through the hoops to secure him. We are looking for a rural lender that would be a good speaker to present some of the issues that they are faced with, to go along with Mike Tankersley on the rural appraisal. And then Colin is working with Greg Gonzalez to secure a federal regulator. But we're moving forward. The first itinerary was for 7 hours of CE. The bankers felt that was a little strong, so we've backed off to 4 hours. But we have set aside October 15th. So you may, unfortunately, for those of us that traveled to Nashville, we'll be down here in 2 consecutive weeks. But it's moving well. They're excited about it. 240. They have room for 240. I'm wondering if we may push those limits between bankers and appraisers. Should be a good opportunity. Lunch will be provided. We're talking about mixing up appraisers and bankers at each table, giving discussion questions during the lunch, and then follow up with Q&A at the end.
So they've asked me to speak in Denver about this. Okay, all right. Anybody have anything else? Any old business?
That's something.
Yes, go ahead.
Sorry, I know we're ready to get out of here, but I just wanted to bring up something that we just kind of discussed and where I was going with that question. So, on the residential side of our industry, and I don't know how familiar you are with this, but there's some things that are changing in terms of bifurcated appraisals, which means that you're now not only going to have, or you can have a different person inspecting the property as actually signing the report, and there's no licensing requirement for the inspection. That's where I was going with that. If we considered that part of the appraisal process, Tennessee state law 6239-102 says that appraisal means the act or process of developing an opinion of value of real estate. I think it's something that hopefully will be discussed at Arrow, but something that we definitely need to consider where our jurisdiction falls within that. We had a complaint that was directly related to property inspection and measurements, and if that falls under our jurisdiction or not. But I think it's a question and a topic that we do need to start exploring.
Else? Well, ladies and gentlemen, this coming weekend is a very special weekend in this country, and I would ask that you spend it with your family. So I'm on the record. I said it's a very special weekend. Before we adjourn, I'd like to ask you to spend it with your family. And I'd like to say, God bless each one of you. God bless our industry, and God bless our country. I entertain a motion to adjourn.
So moved.
All those in favor, leave. Thank you.
Thank you.
Thank you.
Hey, what are you speaking on?